Yes.
May I say, Malad, that one motion regarding blacklisting that is tomorrow.
What blacklisting?
Blacklisting of farm members.
May it please, Your Lordship. Well, item 29 and 30 after the motion. Deep level.
Why you are not trying your luck out there in the division bench?
No, well, the
Pull
division,
up all these two matters because the issue is there. It is also deciding.
the division bench, I think will await Your Lordship. That is the view which was expressed on the last occasion. Deep level.
But may I plead for application of item number 46, Your Lordship. It is an IOCL tanker matter, Your Lordship. Somehow it's still again listed in the orders column.
Oh, those matters
Yes, Your Lordship.
where Mr. Kane Chaudhary is appearing.
Yes. You can consent of Mr.
Where item?
Item number 46, Your Lordship.
Okay. Take it for admission.
Deeply.
May it please before your
Don't
lord,
expect much today. I don't want to take further additional pressure. I don't have CAB. I don't want to make a scene.
may it please before your lordship. Lordship, with the consent of the other side, I beg to mention item number 18 of today's daily list. I have filed a prior adjournment slip yesterday, lordship. My senior is,
You want an adjournment?
yes, lordship.
When?
Lordship, yesterday I filed my prior adjournment slip. Lordship may kindly accommodate me for the day, lordship.
When do you want?
According to lordship convenience, any day, lordship.
My convenience is in the month of July.
Lordship, after 3 weeks.
My lord, I am for the IOCL, my lord. They
Hmm?
stay operating in their favor, my lord. Since they have a problem, let the matter come up next month, my lord, in the month of January, my lord. 18th, Jyotsna Chaudhary, my lord.
At the request of the counsel appearing on behalf of the petitioner, matter stands adjourned to be listed on 19th of January 2026.
Lordship, there's a-
Interim order passed earlier shall continue till then.
Obliged, lordship, obliged.
58 also. Separate list.
Huh?
58 also, separate list. 58 also. 58 also.
58, yes.
The counter petition also. 94 in reply also.
What do you want?
Counter petition also. Other part, I feel reply also.
Now, what do you want this?
The petition also.
Withdraw.
No, after application.
At the request of the learned counsel for the petitioner, the matter stands adjourned to be listed 6 months. Okay. To be listed again on 18th of May 2026.
May it please your lordship. In regard to item number 25 of today's list, I have filed an affidavit in reply. I have filed an affidavit in reply yesterday. I'm praying for calling for the record of the affidavit in reply. Obliged.
May I please, Your Lordship. For motion tomorrow, my secretary. As they mentioned for listing of a requisition, my lord, I have a notice was issued on in the month of May, my lord. Matter particular payment, my lord. About the contact, my lord. Work has already completed, my lord. Some administrative approval is required, my lord. So, my lord, the lordship's interference is required, my lord. So, matter will be taken up on next Friday, my lord.
Motion?
No, my lord, admission.
No? Rejected.
May it please, your lordship, we had filed an affidavit in opposition in regard to item number 60 of today's supplementary list. Lordship, maybe much obliged, lordship.
May I please follow? In item number 11, we have filed one joint affidavit. That will call for the.
Lordship, I have filed one IA for correction of order, lordship. That will be on Friday, lordship.
Correction?
Yes, lordship.
Mention item 22, your lordship. Item 22. The Lana Council is.
What do you want?
Adjournment.
Interim? No interim. Chalo. At the request of the learned counsel appearing on behalf of the petitioner, matter stands adjourned to be listed again on 24/2026.
I need to mention for listing on motion matter, content matter, my lord.
Tomorrow?
Tomorrow,
May it please,
My lord, we have filed an affidavit in opposition.
You want to call for?
Sir.
You want to call for?
Yes.
All calling applications allowed, huh? Just ask them. Next.
They mention item number 4, Lordship. Lordship, may I allow to report this matter with liberty, Lordship.
No liberty business. What
Lordship,
liberty?
We are person and other Lordship, date has been wrongly typed, Lordship. That's why I am allowed to press, Lordship. I have challenging the promotion order, Lordship. The promotion order of the private respondent, Lordship. Now, I wrongly typed, Lordship, the order date. Therefore, Lordship, may I allow
Your name?
PJ Dutta.
Mr. PJ Dutta, the learned counsel appearing on behalf of the petitioner submits that there are certain formal defects in the instant writ petition, and as such, the petitioner would like to withdraw the writ petition with the liberty to refile. Full stop. Taking into account the above, the instant writ petition stands closed on withdrawal. However, liberty is given to the petitioner to refile by removing those formal defects.
May I please your lordship, I am praying for listing a motion matters.
May it please your lordship. So lordship, I'd like to mention item number 27, your lordship. In this matter, the respondent number 2 has filed a affidavit in opposition. We would like to file our rejoinder to that, your lordship. I pray for 2 weeks' time, your lordship.
Interim?
Interim, no interim, no interim. I'm not objecting, but this is a matter. E-auction was conducted in the year 2023. Now they became aggrieved, lordship, and filed this petition, lordship. We rejected the tender because of 2 reasons, lordship. One, at that point of time, he was a defaulter. And second, the earnest money of the second bidder was deposited from his account. On that ground, lordship, the e-auction was cancelled. I will not, no urgency is there. Let's take up our petition.
The learned counsel appearing on behalf of the petitioner seeks for an accommodation. List this matter on 4th of May 2026.
My lord, may I pray for a date in the month of January? My lord?
No.
Why not?
What January?
My lord,
When did they file the reply?
They filed it the day before yesterday. We
No.
received the copy yesterday.
I don't grant, Mr. Counsel, I don't grant adjournment at the time of motion, at the time of mentioning on filing of the reply. Nothing doing.
Why don't you take up the matter?
Very well.
My lordship,
Okay.
my lordship, we are for listing lordship, motion matter lordship. Tomorrow lordship.
Matter of exam for the
6.
yes, lordship.
What is the matter about?
Matter for the vendor of a stamp vending shop, lordship. His shop was, his license has been cancelled, lordship.
Oh, you know the matter. We'll do it. You do it.
I-
You know that. No, you do it. We'll see. We'll stand when the matter is taken.
May it please, your lord. So along with item number 1, item number 59 is also connected.
What is this?
59
So
is
many
item-
eyes. What is this?
This is the matter regarding PF contribution, PF area use. The last of it when the matter was moved for lordships. The challenge was, though we were given 36 months initially for depositing the area, later on it was.
You paid the 63 lakhs.
No.
Yes, that is that. Therefore, I have filed this IA lordship.
You have not paid?
No.
Oh, we vacate the stay.
It will also kindly consider the IA for a moment, lordship. That's why I
No.
filed an IA. The difficulty is, lordship, that
Absolutely no. Why should we entertain at all?
my only prayer.
Mr. Sharma, this order which is being passed out here
It's a very apt order.
should not have been passed at all.
I understand.
I, on that day, was in a very good mood to give you time for depositing this 63 lakhs, which I should not have. Later on, while signing it, I thought that I should not have. You are liable to pay a huge amount.
Our prayer was that initially the 36 months that was given, 36 months installment period was given, that was the time appropriate for us, we could have managed. But then it was ultimately reduced to 10 months. That was our challenge before Lordship. Lordship was very grateful to give us.
Mr. Sharma, you have to understand that 36 months is also over. All this period is over now.
That was April 2025, Lordship.
Then we are in December. You have not paid a single penny. I gave you therefore the opportunity against the submissions so made by Mr. R. Sharma, isn't it?
And even from subsequent to Feb of this year till this December, October, they have not paid the present dues also, which has come to now 61 lakhs.
The difficulty that.
Not paid on or before Emmanuel will be a late. Have you initiated action?
No, because
Okay. We dismiss your petition. You don't have a case. Oh, division bench.
Let the petition remain, Lordship. Let
No. What is there? Tell me your case. You don't have a case.
My case is a case of legitimate expectation.
There's no legitimate expectation in this.
Because a right.
First,
to
no, Mr. Sharma, the concept of legitimate expectation is too foreign. It's
If,
foreign, it's not a right.
no, if there is an order in my favor.
No
the
order.
Authorities.
No, but
Giving me a period.
but that order has no relevance taking into account that that period is also over.
It's not over, Lordship.
It's
That
over.
period started from April 2025. And 36 months thereafter.
No.
That period is not over, Lordship.
No.
So, Lordship will see that order at page 59 for a moment. So my only prayer today in this IA was just a 1 month time because of the coal season that is going on. There is no production at all. And since there is no production, there is no revenue generation. So therefore, the authorities are the petitioner are finding it very difficult to make these payments because they also have to make the labor payments also. PF is only an additional amount. Labor payments they are making regularly, Lordship. All these expenses are there. Page 59 is the order. This is of 29th and 2024 Lordship. Wherein we were given a period of 36 months for making the payments at the rate of 6,37,000. At
Where?
page 61, we gave all the post-dated checks and we have made the amount more, that is 9,56,000. Because what the authorities gave us, we were supposed to pay from the month of January. Since there was a full season again, what we did was we gave our checks from April, but we have increased the amount from 6 lakhs, we made it 9 lakhs. So that we can finish the amount within 36 months itself. We never wanted to go ahead the 36 months. So we made that amount in 36 months. Suddenly it was cancelled at page 62 by issue order dated 24/3/2025. Without any rhyme and reason, it was cancelled.
No. I give you the rhyme and reason. Read page 59. The rhyme and reason is very clear. Read it very properly for everybody also to know what is the rhyme and reason. Read it, the contents.
With reference to the above, I'm directed to state that Chairman Board of Trustees, in consideration of all the facts and circumstances and on your representations referred above, is pleased to pass the order as follows. To deposit the PF administration cost amounting to rupees 694,714.25
Immediately.
immediately.
Yes.
Thereafter,
Have you done that? No, I'm asking you. No. Next. Number two.
to deposit the area PF contribution amount of rupees 229,40,378 payable for the period from 29/21 to 36/24 in 36 equal installments at a rate of 6,37,232 with effect from October 2020
With effect from 2024 October. Then,
to deposit the current PF contributions
which you are also not doing it. Then,
to deposit the area DLI dues
which
immediately,
also you have not done. Then,
pensions, DLIs, gratuity claims immediately.
yeah. Then read the next slide.
In this connection, you are hereby requested to submit necessary post-dated checks towards the payment of the aforesaid 36 numbers of monthly installment within 15 days from the date of issue of this letter positively.
Date of issuance of the letter is 29/10/2024. You sleep over. Then you wake up on 10th of January and submit these post-dated checks. You were required to pay on 10th from the month of October. So now you see the rhyme and reason.
The period given to me was 36 months.
Forget about that. That is not material. Division bench, we dismiss your petition
I
right
did
now.
not go there, Lordship.
You go there. I am not going to do that.
Lordship, if I may just submit one thing, the period given to me was 36 months.
No, Mr. No, you see, first and foremost, when an order is being passed out there, giving you the scope of making payment by way of installment, then in that regard, you are to follow as per that. This court cannot pass an order asking them to give you another installment period. I only said, therefore, by way of an interim order, will consider later on, first you deposit that 69 lakhs, which normally I would not have done it on any other day. But that day I was in a very good mood. So no case, we
They would
dismiss it
never
today.
like to-
Let me correct the mistake which I have done.
This is their own tea estate. They would never like to lose this tea estate. If they would have paid this money, they would have very well paid the money. But the problem is there is no fund at all in this tea estate. So therefore, some time is what they are asking. Another 1 month.
Oh,
time
fight
for
out the other case. Fight out the case when they take a action appointment of a receiver, then you fight out what is to be done. Not this. Interim order has been vacated. This have not been complied with.
Therefore, I filed this IS stating that I have filed a representative report
No,
of PF department
I,
asking for a month's period of time.
no. I do one thing. I dismiss this petition, then IA is gone.
Lordship may dismiss the IA and keep the matter pending.
No.
What
IA,
can
they,
authority can do whatever they would like to do. Because Lordship has made it very clear in the interim order, if the payments is not made, then there is no power on the authorities to move in accordance with law. That will always remain. My IA can be dismissed then. If Lordship is my IA,
IA is not for before me.
Lordship, it's there.
It's there, but today is for motion only. Wait, there is another matter, 59.
59.
What is
the
that?
IA. That is the IA, Lordship.
Oh, IA.
It's connected.
But the motion has come.
Along with the
Why
IA.
the matter come up for motion? Shouldn't have been come. I have issued notice.
Yes, sir.
We'll take when the matter reaches, not now. And at that time, we'll dismiss. This shouldn't have been taken as motion. IA motion was taken. Then
This matter has come with motion and it is
it
connected.
can't
with
come
the
up
IA.
as motion. It is
That's
a,
what shows in the
it is a
constitution.
case. Is it fixed at 10:30? No.
Item number 1, Lordship.
Then item number 1 can I get? This is item number 1.
This repetition is item number 1 today.
Okay, so then we dismiss it right. Item number 1 only starts. You can go down.
The Lordship will give me a week's time
For what?
to try to comply with the order.
Week's time? 19th. Week is 19th.
19.
I can only allow till 19th, but I don't think. I should not further commit any further mistake.
Let me give this message to the client that this is the situation in the court. If they can, let them do, or else I
We
have
will
withdrawn
we
this
will
motion.
take up that matter for orders. That matter. In the meantime, start messaging your client. Next.
The 19th, Lordship. 19th.
What 19th?
19th, let the matter be listed again, Lordship.
No, today only. Today only it should be 19. There are a lot of other matters. যেটো হবো অকণ পিছত হবো মোশন এইবোৰ orders যেতিয়া ল'ম তেতিয়া at around 4:30.
Obliged.
What is this, Mr. Manan?
For optical fiber cable, his tender was ultimately terminated on the ground that he could not compute. He has given the letters to the authorities that he could not. compute.
You are terminated.
Yes, terminated, and they have also directed that his the location has also been. The Lordship, what has happened? In fact, what he has alleged was that there are some pipelines and he could not lay down the cables at that area, and the other area, another part of one part he has done. The other two parts he could not do because one is under the National Highway Authority and one is, there are pipelines. And they did not even give any opportunity and terminated. Now, after the termination order, Your Lordship, they issued two letters to him. One by the National Highway Authority saying that yes, this area is under us,
and you had to take a permission from me. Another was from the Deputy Commissioner Office saying that earlier permission was granted only for the part where there is no national highway offer. Now they have issued the tender for the rest of the work which was not done. That they have already issued that tender. Now they have given the place as aerial tender. Now they have made it an aerial tender because there were pipelines and so admittedly what we have alleged are correct. And therefore they have now made it an aerial tender, the next tender. This is the basically gist of it. Now we have come, your lordship, because we are also not participated in the tender, we are not allowed new tender. The process is on. And we are only concerned with the amount which we have, your lordship, completed. That is nearly half of the part.
Where?
Now termination, your lordship, is fine. Kindly take it at page 99. I'll take your lordship to the other two pages also after the termination. This is the rescheduling termination of the contract that was on 25/4/2025. And after that, your lordship. And on the next page, 91, that is invocation of the bank guarantee. Now your lordship will find at 34.
Wait, let me read it.
Yes.
You have gone through it. I have not gone through it. Wait.
The first paragraph itself, the cause has been stated.
Now here you have been terminated on the ground that you did not do any work.
Yes.
Yes. Did you do any work?
Not, they have admitted the fact that certain work has been done. But our case was with regard to the permission of laying down bituminous with regard to permission from NHIDL. DCL is not required that they have stated. And second is that the charges that we have made, that is completely unfounded. Now kindly turn to the next page. Next page is invocation. This invocation of the bank guarantee, then the next page. Page 92. This is from NHIDL. Exactly what we have stated, they have stated. They say it is unfounded. This is the letter issued to me by the NHIDL. Then your lordship will kindly go to page 93.
Who is to obtain permission?
That is it. The permission will be taken by the lifts. That
By the?
is the BSN. That is then is an order by the DC where it says that it has to be taken by the, I'll take your lordship to the order. That is, DC's order is at page.
Okay, we'll issue notice. Nothing more than that.
Another letter that was also issued by the DC office saying that yes, permission was not.
No, so what? You have approached this court after 8 months.
No, we have initially we have approached your lordship, but
Then?
the challenge was not made to the termination. Then again, we withdraw with a liberty and we have terminated.
Where is that order?
The order has not been announced, but the statement has been, is 17 minutes, please. Para 19 minutes. And it was withdrawn on 26/11/20.
So when did you file this writ petition?
This was filed there. That was,
Did you withdraw at the motion stage?
no, oh yes, because after the instructions, it was changed.
So you must have filed very late. On 26/11.
Maybe your lordship. No, that was not on the very first day, but the instruction.
Anyways,
Anyway, your lordship will issue.
but why should we go into all these things here?
Because the termination per se is not correct. And therefore, you have, I am entitled to the amount.
And damage beyond 1 meter shall be charged. This is under the Right to Information Act, page 92.
92. No, 92 is actually issued to us.
Hmm?
Yes.
Why did he issue your letter dated 34? Where is your letter dated 34?
That letter is not in. That page 93. They have admitted the fact. They 68 actually, your lordship. Is the. initial
No, no,
order.
tell me,
It's page
why
68.
you have been asked to obtain the permission after rescission?
That is your lordship. I'm just pointing out one thing, page 68 for.
No, no, tell me one
Yes.
thing, at page 90, on 25/4/2025, your work has been rescinded.
See,
Then on 4/7/2025,
lordship.
a letter is being written by the additional district commissioner to you.
Yeah. They have admitted that this was.
And on 30/4/2025, another letter has been written. Now here it says, you are therefore requested to approach NHIDCL Silchar for obtaining separate ROW permission for NH 36. Now, where is it that
Page.
who is to obtain the permission?
Page 68 for a. Page 68. 68 is the initial, your lordship, permission, grant of permission by the deputy commissioner. Here, your lordship, first to the licensee. Licensee is the Bharat Sansar Nigam Limited. Now, your lordship will come down to serial number 4. That is the last part. Permission is granted on following terms and conditions. The licensee shall obtain necessary permission for laying optical fiber, network underground telegraph, so and so. And number 2 is that the work shall be started from the outer area of this. So it is the licensee who is entitled. We are not entitled. Though if the letter was written to me to take permission, it is the licensee who will take the permission and then grant.
Who is the appropriate authority?
The NHI and.
No, this one. Is it mentioned who is the appropriate authority?
The nodal office. BSNL in page 71, 71A, the BSNL have taken the permission from PW. That is given. That is why that part of the road we have done. Now, with regard to NHIDCL, that was not it. BSNL that we have annexed at page 71 is the type copy, 71A. The amount of bank guarantee has been deposited with the PW. Page 17. This permission was taken by BSNL.
Where is your statement that, where is your, that you want to take the permission, that you have not been granted the permission, any letter?
Here are that. We have issued your lordship two letters. First is at page 82. And page 84. There are two letters, your lordship. Page 84 is detailed letter with everything.
Now, page 82, they don't say about the permission from NHIDCL is required by you.
That is not said by that, but in page 84 again we have issued another letter, your lordship. There are two issues. One is with regard to the pipeline and second is with non-permission from the NHIDCL. Here we have stated that. Then they issued the other letter, which they refused to accept mine. Which and in fact, the permission will have to be taken by BSN. Though I have approached the office. After this letter at page 87, they have issued a warning. So they said that the initial received permission was the ultimate permission, but that is not true. And in fourth paragraph, they have stated that after completing 11 kilometers of work, we have stated about the obstruction. They said that already permission has been given, but that permission is regard to PW only.
What did you write to this letter to the 7/3/2025? What is your reply?
3/25, and again they have issued another, no reply to your lordship. Again on 4/4, they have again issued another letter. Here at page 89, they said that our allegation is incorrect and not accepted. As permission has been granted, but in fact the permission was not granted. And thereafter they immediately rescinded the contract on 25. And after the rescinding of the contract, they have issued these two letters, admitting the fact that yes, there was no permission.
Now, in the fresh tender, what do they say?
they are saying that first tender, they are saying it is a tender for aerial. That your lordship will find at page 96.
Tender for?
Now, no, page 96.
Hmm.
Here now your lordship will see serial number 1, name of the
Aerial
body.
ADS.
Aerial optical, because of the fact that there was no permission for the ground and we were allowed for the ground mission. So, admittedly, there was no wrong in our part. Whatever we have done that 11 kilometers, admittedly, they have stated. We are only claiming that the amount which we have entitled to, that we are claiming.
We are paying for BSNL. Huh? Okay. But Union of India is represented by the chairman and managing director of BSNL. Is it possible? Huh? Why are you making a PWRD a party?
PWRD, actually the amount that we have given, the bank guarantee, that was deposited by BSNL to the PWRD. They have given the permission for the first part, which we have completed. It's part of 11 kilometers. That was under the PWRD. The rest
Your
part-
bank guarantee is some 4,94,000. Not much. But why you are making the PWRD a party?
That part we have completed. If required, your lordship, because.
Now,
that
how
part-
many causes of action are you going to
No, because
join together everything?
ultimately there is.
Your case is, you see, there is a wrongful termination. And this termination could not have been at the risk and cost of mine, taking into account it is not my fault. First, the permission of the BSNL is required for that particular area. Others you forget it, but that particular area is required. So your issue is squaw the BSNL. But why have you made everybody who is there or having any link anywhere have made a party, and the most pertinent person you have not made a party? Union of India.
Yeah, I think.
BSNL is you have not made a party. Where is BSNL? Huh? Can the principal general manager appear on behalf of BSNL? That's state of affairs. You file properly an application.
File these proper costs.
And remove all these other people, no? Unnecessary. Make that. And if you want to make NHI DCL a party, why are you making the general manager a party? It is the company or the entity who has to be made a party. You withdraw this with a liberty and file a proper one.
Cost side.
You have to make, okay, you file a proper cost title means you have to file an amendment application. An application properly, taking out somebody, application for deletion and a substitution. You have to file
And
it
that
fresh.
we have to-
That is what I am saying. Instead of that, otherwise this will take another time.
It will take.
Mr. S. Manan, the learned counsel appearing on behalf of the petitioner. And make the Union of India party properly. And the BSNL,
See,
they have a standing council of the BSNL. I think Mr. Bibhas Pathak appears. But they have put it all, SC, BSNL, SC, NHI, DCL, everybody's name is there in the cause list. Everybody's name is there. Boss. You have given copies to anybody? Whom have you given copy? SC, BSNL?
Probably they have served only one copy, the central government office lawsuit, that's why.
Hey, Nila file to the house.
second file is Buddha.
Nila file to. Second file to you. Ah, for B Pathak somebody has taken. I'm taking it. He has been given. That is what I'm saying. He has given it to everybody. Union of India, it has been given. Government of Assam, SC so and or SC, NHIDCL, everybody has been given. You are paying for NHIDCL. Huh? Okay, heard Mr. UYS Manan, the Learned Council appearing on behalf of the petitioner. The Learned Council submits that the parties who have been, there are formal defects in arraying the parties in the instant proceedings. He therefore submits that he may be permitted to withdraw the instant petition with a liberty to refile by removing those formal defects. Taking into account the above, the writ petition therefore stands closed on withdrawal. However, liberty is given to the petitioner to file a fresh one by removing the formal defects. You make Union of India Department of Telecommunications. Then you have to make the BSNL a party. Then you make all these other 2, 3, 4, and 5. Then you have to make the SBI a party, not the branch manager. Branch manager would be represented by the branch manager. Then you have to make the NHIDCL a party. And restrict your cause of action to a particular thing, not involve everything which is there on earth.
Like,
May I please?
Oh yes, tell me.
Lordship, I am before your lordship against the appellate order passed by the competent authority.
After I remanded,
Yes, before that. And appeal, interestingly, appellate authority, page 106, lordship, kindly.
yes.
Paragraphs 2, 3, 4, and 5, I am reading up. Observation. My lord, in this case, what happened? My license was admittedly granted on 14/9/2022. Inquiry conducted for the period July and August, my lord, before issuance of my license. And in paragraph 3, they are referring to my father license. I have succeeded. My father was never a, my lord, PDS license holder. And I have stated in paragraph 15 that I have succeeded the license from another person who, after his expiry, the PDS license was taken with another person from whom license was granted in favor of me, my lord. In a wrong premises, my lord, the respondent authority, appellate authority has decided the, my lord, appeal, my lord.
Hello. Issue notice. But if I remember correctly, after 14/9/2025, 22 or whatever may be,
Yes.
the PDS quantity was lifted by somebody else on your behalf.
Not my behalf. That was their filed affidavit. I have
No,
received-
that is why I wanted to dismiss. Then I gave you the chance to go and appeal.
What happened in that case?
Anyway, let us
That is
issue
an evidence
notice.
observation, my lord.
Okay, issue notice making it returnable on 2nd of February 2026. Mr. K. Gogoi, the additional senior government advocate, accepts notice on behalf of the respondent numbers 1 to 4. Extra copies of the writ petition be furnished by tomorrow. The petitioner herein is aggrieved by the cancellation of the license, cancellation of his fair price shop license by the order dated 22/1/2024, as well as the order dated appellate order dated 20/11/2025, passed by the Secretary to the Government of Assam, Food, Public Distribution and Consumer Affairs Department. The learned counsel appearing on behalf of the petitioner submits that the basis on which the impugned appellate order was passed is erroneous, taking into account that it has based its decision on an magistral inquiry report which preceded the issuance of
That
the
was
license to the petitioner on 14/9/2022. He therefore, 14/9, he therefore submitted that the instant case, the impugned order of cancellation of the license as well as the appellate order cannot stand the scrutiny of law. The respondents herein are directed to bring on record their stand by filing their affidavits on or before 28/1/2026. Full stop. What is this? What is detergent going on here? Freight subsidy.
Freight subsidy, on consideration of the freight subsidy. And subsequently, Lordship, it is to our information that the state level committee has rejected it, but we have not been received any correspondence in that regard.
Who?
State level committee has already rejected it, but we have not received any correspondence in that regard till now. We have been following up with the DICC, District Industry Commerce Sector, but no correspondence has been received.
Then?
For consideration and, we have filed this petition for consideration dispersal of the,
But tell me,
Lordship.
this was rejected in the year 2019. Why after 6 years you have come before this?
Not rejected in 19,
No, this is for the period of 2019.
period of 2019.
Why you have come before this court
Lordship,
so late?
Lordship, see that we have given a reminder in the year 2023.
No, reminder, no business out there.
Then in 2023, it was forwarded by DICC to the Commissioner of Industries, Annexure 8, page 94.
Yeah, kindly come to paragraph 15.
Yes, paragraph 15, that was in 2024, that we have information that still.
In the 22nd meeting of the state level committee held on Iman, the claim of the petitioner was rejected on the shortfall of documents. Then?
That is why information, in respect of other periods also we got the information, then para 17 Lordship will find. We have stated that we have been following up with the department, but they have failed to give any correspondence in that regard. The petitioner did not resort, the High Court as a first approach and tried to cooperate with the department. But since they have not, given any correspondence to us of rejection or clearing any additional document, ultimately we preferred, the present restriction. Lordship.
What is the shortfall?
We don't know. That is not,
That I will place, my lord, but one thing, my lord, if it has been rejected by the minutes of 27 to 24, that will have to be put to challenge, my lord. That is the main cause of action. my lord. But I will place the, my lord. if
He
it-
says that he doesn't have a copy.
That I will place it, my lord, then I will place that copy, my lord.
Huh?
Next, that I will place that copy of the minutes, if at all it is there and it has been rejected.
we had claimed for 15 quarters, Lordship. For other quarters.
Okay. We issue notice making it returnable on 9th of February 2026. Mr. B. Gogoi,
Good free.
Mr. A.K. Datta accepts notice on behalf of the respondent number 1. Mr. B. Gogoi accepts notice on behalf of the respondent number 2, 3, and 4.
Well.
Extra copies of the petition be furnished by tomorrow. The case of the petitioner herein is that the petitioner, in pursuance to the freight subsidy scheme 2013, had applied for the benefits for the period from 1/7/2019 to 13/9/2019, which is to the tune of rupees 6,31,540. Full stop. It is the further case of the petitioner that the petitioner submitted the claim submission, the application in respect to the said period on 29/9/2020. And thereupon kept on inquiring with the respondent officials as regards the claim. However, nothing has been informed to the petitioner, except the petitioner could come to learn from certain reliable sources that in the 22nd meeting of the state level committee held on 27/2/2024, the claim of the petitioner was rejected on the recommendation of the General Manager, District Industries and Commerce Center, Kamrup, on the ground of shortfall of documents which was never intimated to the erstwhile company of the petitioner. It is under such circumstances the petitioner has therefore approached this court. Mr. B. Gogoi, the learned counsel appearing on behalf of the respondent number 2, 3, and 4, submitted that a very perusal of the petition, and more particularly the relief sought for, would show that the petitioner have not challenged the decision taken in the state level committee of Freight Subsidy Scheme 2013 in the 22nd meeting held on 27/2/2024. He therefore submitted that without a challenge to the said decision, the instant writ petition is not maintainable. Keeping the point of maintainability open, this court directs the respondent authorities to bring on record the stand by filing the affidavits. Next date kete also. On 2nd of February 2026.
Lordship, petitioner is a family member, Lordship, who was running out of family shop Lordship in the premises of District Commissioner Nagaon Lordship. Thereafter, suddenly on 6/5/2025, he lost one blank stamp paper Lordship, stamp paper.
Hey, you have a good case. Why you are taking adjournment? You were a person who asked for adjournment. Then you should notice making it returnable on, it's a case of suspension. We have it in the month of January. On 21st of January 2026. Mr. K. Gogoi, the learned additional senior government advocate.
120.
Madam, very difficult. Who is respond number 1? Tell me.
Which department they have not?
Which department?
They have not mentioned laws.
Huh?
They have not mentioned laws.
No, what should be the department?
It should be by that state of Assam represented by the Commissioner Secretary Revenue Department.
Okay, Revenue and Disaster
Revenue
Management.
Disaster
Sure.
Revenue.
Issue notice making it
And in
returnable
respect-
on 21st, 21/1/2026.
Respect to response number 2 also, my lord may kindly peruse. Response number 2, lordship.
The petitioner, counsel appearing on behalf, Ms. So-and-so, the learned counsel appearing on behalf of the petitioner submitted that there has been an inadvertent error in mentioning in putting the full description in respect to the respondent number 1. The learned counsel submitted that the respondent number 1 ought to have been the state of Assam represented by the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department, having his office at Dispur, Guwahati 781006. She therefore submitted that she would be filing a fresh memo of parties in this regard.
And Lesson number 2 also, Lordship, the magistrate branch should be removed, Lordship. Lesson number 2 also.
Who is the revenue department? Any revenue department? Anybody, have you
Lordship,
seen Mr. S. Dutta or who are they? Revenue?
PR Mohanto is there, Lordship. PR Mohanto I have seen, Lordship.
Huh?
PR Mohanto I have
You have seen?
I-
You give her the notice.
Lordship.
Ms. PR Mohanto accepts notice on behalf of the respondent number 1. Mr. K. Gogoi, the learned additional senior government advocate, appears on behalf of the respondent number 2 and 3. Who is 4? 4 also.
For notice have to go, Lordship. Stock holding, Lordship.
4, 2 and 3. Pustu. Extra copies of the writ petition be furnished by tomorrow. As regards the respondent number 4, the petitioner is directed to take steps by way of speed post by tomorrow. And further, the petitioner is also given the liberty to effect service upon the respondent number 4 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner was given the license of a stamp vendor in the year 2018 by the respondent number 2, bearing license number 8/2018 dated 29/9/2018. The said license was further updated on 26/7/2023. It is the further case of the petitioner that the petitioner have been diligently performing the duties as a stamp vendor. However, unfortunately, on 6/5/2025, he lost blank e-stamp paper along with some other belongings for which he had filed an FIR on 9/7/2025, which was registered and numbered as, what is the number?
It's not there, Lordship.
No number also.
It's not a certified copy, Lordship.
Huh?
It is not a certified copy also, FIR.
Had filed a lodged an FIR before whom? Before the officer in charge of Hoibargaon police station. Be that as it may, on 19/7/2025, when the petitioner submitted an application for reopening the account of the petitioner before the respondent number 4, the respondent authorities the petitioner came to learn that his account has been suspended for selling e-stamp. It is under such circumstances the petitioner has approached this court. Full stop. The respondents are directed to bring on record their stand by filing the affidavit as to why the petitioner's account has been put under suspension. The said affidavit be filed on or before 19th of January 2026.
Lordship.
Petitioner is consumer of private person number 5, Lordship. And on complaint, Lordship, license, PDN license of private person number 5 of suspended. On being found misappropriation of PDS assets.
So you agree by inaction by the district commissioner?
That was suspension was done, Lordship. License was suspended after thorough inquiry, Lordship, but that was withdrawn by the same officer, only saying that some warning is given to the licensee, Lordship.
Is there, Mr. That is the Lahori Hat. This is not Lahori Hat.
No, no, Lordship.
In Nagaur,
No. Page 22, my lord, may kindly page, page
it is the impugn order.
22.
22, why should I look into it?
Lordship.
It is not, this court would not, you have already approached the district commissioner. It is the district commissioner who have not taken any action, therefore you have come before
Lost.
us. That's all, isn't it? Scope of the requisition is that
Yes.
issue notice making it returnable on 16th of February 2026. Mr. K. Gogoi accepts notice on behalf of the respondent numbers 1 to 4. As regards the respondent number 5, the petitioner is the extra copies of the requisition be served upon him by tomorrow. As regards the respondent number 5, the petitioner is directed to take steps by speed post tomorrow. So the petitioner is further given the liberty to take steps upon the respondent number 5 by way of dusty routed through the registry of this court, so and so. The petitioner herein is one of the beneficiaries of the fair price shop of the fair price shop of the respondent number 5. The petitioner it is the case of the petitioner that various allegations that the respondent number 5 have indulged into activities which thereby violating the mandate of the Assam Public Distribution Order in 1982 and the license issued to the respondent number 5. In that regard, a complaint was lodged before the respondent number 4. And however, after initial suspension of the respondent number 5, the respondent number 5 was let out with a stern warning. Under such circumstances, the petitioner had, along with various other consumers, submitted a representation before the respondent number 2. However, as the respondent number 2 have not taken action, Mr. Counsel, I am not going to issue a notice in this case. No, I am dismissing your case. This happened on 29/11
Lost.
and you want immediately. 15 days have not gone by.
Impugn order was passed.
Forget about the impugn order. You have approached them. You have not come against the impugn order directly
Maybe
before
taken
this.
after vacation, Lordship.
No,
Time
this
is
court is going to dismiss it. Why should I?
lost.
No,
So
I
no
was
time
not
to-
talking. Issue notice.
After vacation.
You withdraw with liberty to file again.
Lost.
Yes. No, question doesn't arise. 29/11 and you are, what do you think this?
Impugn order was passed. on
Forget
14th.
about the impunity. You have already approached another authority. Mr. M.K. Hussain, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be well advised to await for some more time as the representation was submitted to the respondent number 2 only on 29/11/2025. Mr. K. Gogoi appears on behalf of the respondent numbers 1 to 4. So taking into account the above, the learned counsel therefore submitted that the petitioner would therefore not like to press the instant writ petition. However, liberty is given to the petitioner to again approach if in the circumstance the respondent number 2 does not take any steps. Mr. K. Gogoi appears on behalf of the respondent numbers 1 to 4. Taking into account the above, the instant writ petition stands closed on withdrawal. Liberty, however, is there to the petitioner to approach this court after 3 months from the date of the present order if the respondent number 2 does not take any action.
Oblations.
Here the petitioner was illegally and wrongly terminated my lord.
What?
The termination order letter is at page number 40. My lord, in this, my lord, case, the contract was awarded. Without giving any reasons on first one. And the said letter was not even addressed to the petitioner. There too we have issues.
What is the performance guarantee?
Performance guarantee is, the amount of the performance guarantee is 1,22,000, my lord.
What is that performance guarantee? How did you give it?
We have given it by the fixed
Huh?
deposit, my lord. Which is a page number, my lord. 32. 32A, my lord, is the performance type of it. Not a type of.
So your only grievance is not returning the PG.
After returning the PG as well, my lord, but termination has been wrongfully terminated, my lord.
Where is the termination?
Termination is the 40, page number 40, my lord, the letter which we have got to know in the month of November, my lord.
Huh?
Which the letter is at 40 pages, my lord. Just now, my lord, have gone through it. Said letter which we have got to know in the month of November, my lord. No written notice was given, my lord, as per the agreement, my lord.
But issue notice making it returnable on 9th of 11th of February 2025, 26. Mr. H. Gupta accepts notice on behalf of the respondent numbers 1, 2, 3, 4, 5, 6, 7, 8, all. Extra copies of the writ petition be furnished to him by tomorrow. To stop. The case of the petitioner herein is that the petitioner was issued a contract for
Monthly basis cab and taxi service.
where do I get it?
There- at each number.
Page 23, my lord. that
Page
is
23, my lord.
Contract.
Page?
agreement.
Page 23, my lord.
20?
Three.
Service.
Where will I find it?
Service description is written in bold, my lord. In the
Concern-
middle, my lord.
Huh?
In the middle, service description,
Concerning details.
consigning details,
Where is it?
in here, my lord.
Where?
Third table, my lord.
Monthly service, monthly basis cab and taxi hiring.
It is the case of the petitioner that a petitioner that by way of a contract was entered into by and between the petitioner and the respondent authorities in respect to monthly basis cab and taxi hiring service, that's SUV, 1,500 kilometers per month, outstation 24/7. This contract was entered into on when?
8/12/2023, my lord.
8/12,
2023.
2023. And it was valid till
Valid till
Till today, my lord. Till today, my lord.
till today, my lord.
Till today,
18.
There is a last. date.
Till the last month.
till 18/12/2025,
17/12.
17.
17/12/2025. Full stop. When were you informed?
This, the termination letter we got from.
The termination letter, did you give your service or not? During this period, did you give your service or not?
14 months we have given the service, my lord.
It is the case of the petitioner that the petitioner have rendered service for a period of 14 months. And duly paid the dues. However, from the month of February
On the month of February.
2025, the respondents have not taken the services of the petitioner. Full stop. The petitioner on various occasions approached the respondent authorities, approached the respondent to know the reason. However, the petitioner was not intimated about the reasons. Under such circumstances, the petitioner, it was only in the month of November the petitioner was informed that on the basis of a communication issued by the ADSO/Lumding, LMG, Lumding, dated 14/2/2025, the petitioner's contract was terminated, that too without any notice. The petitioner, on coming to learn, have also requested to return the performance guarantee. However, the same have also not been returned. It is under such circumstances the petitioner has approached this court. The respondents are directed to bring on record their stand by filing the affidavits on or before. It fixed করেছিল 11 February করেছিল না? On or before 6th of February 2026. Anyways, nothing remains. Taking into account, you may have to return the and the pendency pending the next date, it shall not be a bar on the part of the respondents to return the performance guarantee.
Right.
Hmm.
Now, the petitioner before my lord is on a very limited prayer, my lord. She's basically seeking, my lord, a parity of treatment, which was meted out to a certain class of a group of INFL unlicensed operators in rural areas by the state authorities, and has been exempted from two impugned communications that we have put to challenge. My lord, we are similarly situated like my lord, the IMFL on-license holders who were allowed to convert their license to off-license, my lord. So this is the basic premise upon which, my lord, we have come before this court, that the parity of treatment has not been meted to us, my lord. Now, my lord, the present petitioner is a licensee of, my lord, on-license, my lord, perhaps in a rural area, in the district of Brugger, my lord.
You are in rural.
Rural area, my lord.
We passed that order, na? Conversion.
Conversion will take place, but basically they are here stating that this VAT issue, the 6% VAT,
I'll come to that.
they are not, this is not applicable to them because they have filed an application for conversion, but till now they have not been converted yet.
Huh?
To an off license. They are saying we are on license. As per this notification of 7/5/2025, the rural areas were given a chance to convert their on license to off license. They had applied for the conversion. They submitted application. Now the 6% VAT has come in, your lordship, whereby this tax authorities has said you register under the VAT for the on license only. Now they are saying since we have applied for conversion in off, this VAT is not applicable to us. But they are still
That's your
not.
prayer.
My lord, I'll come, my lord. That's my learned friend.
Is that your prayer?
My lord, there has been a little, my lord, not exactly what my learned friend is saying. Because the.
No, I get your point. I get the point out here. It must be. Because from 2015.
Yes.
There is an additional
Law.
tax burden
Yes,
beyond what is you are required to pay at when you pick up the goods from the warehouse.
bonded warehouse.
Bonded warehouse. Additional tax.
Additional tax.
Now, most of the unlicensed people, they have not registered, although they are liable to do so as per the VAT Act. Be that as it may, recently certain notifications have been issued by the commissioner saying that unless you don't
You register.
register yourself,
Pay the
the
area tax.
the question of renewal does not arise.
Exactly. So my second contention before my lordship is that the decisions by which they have now said that I need to register, number one, and pay the area, whatever amount is outstanding against my business, my lord. And if I don't pay, I'll not be renewed. So the main basic, my lord, contentions in order to respond to what my learned friend is saying, my lord, we, since 2022, my lord, when the license was granted, have been following a procedure which has been described in the Assam Value Added Tax Rules under section 10, my lord, 2 Roman 2, my lord, I'll come to that. Under that procedure, at the point of first sale of that item, that is liquor, my lord, we are meant to give a prepaid tax before we purchase that commodity from the bonded warehouse. Now, we since 2022 till today have been following that procedure. Their eyes have, well, I don't know for what reason they have kept quiet, not given us any chance to improve on that. And in 2016, as my lord has correctly said, as correctly said, my lord, that particular provision under which we are following today has been omitted. A new provision was inserted wherein now output tax is required to be paid by us on sale that we make. Now, from 2016, even assuming, my lord, that law has been implemented, but in reality, none of these petitioners have been ever been given the chance to, my lord, change the process that we are going by paying this prepaid tax, and they are collecting, all VATs have been paid, and then we are again renewed our licenses from time to time. Now, the irony is that, my lord, since 2022, under 128, they are required to renew my license every year. For renewal, there are 3 conditions that are required to be fulfilled. That I should not be having any adverse remark, that I should be paying the annual fees, and third and the most important thing, that there should not be any government area against me. Now, the point is, my lord, if I do not fulfill any of these conditions, they will not renew my license. Again, my lord, surprisingly, since 2022, they've been duly renewing my licenses every now and then, my lord. Nothing has been raised since 2022. Suddenly today, they want to follow the 2016, my lord.
Mr. Gugoi, what do you do if the renewal is not there?
Yes, my lord.
Let us say that his renewal is bad.
Hmm.
Then would he be penalized
He'll be
under the
penalized.
penal
If
action
renewal is not done?
for selling any liquor in an off IMFL on license without a license? We have to cancel his license.
Yeah.
now. So we cancel his license and say that you take penal provisions against him, send him to jail.
Difficulty is, my lord, they can take penal action, that's different thing. Now, what they are seeking by this
No,
implementation.
you are selling without a renewed license.
That is.
You are
but
questioning your renewal.
We are ready to. my lord, we are
Mr. Buragwat, let me tell you one thing very clearly. That day one matter came up before me.
Yes.
He had withdrawn.
Hello.
The reason is, see, earlier there are various points of sale. One of the point of sale is that at the time when you take the goods from the, what do you call, the bonded warehouse, you are required to deposit the tax.
Prepaid tax.
It's not a prepaid tax, the
But it's
tax.
but
It's a tax. So you deposit, then they release. This came into being sometime in the year 2003,
3 onwards, my lord,
4.
because the VAT came in from them.
Prior to that, it was also there in the Assam GST Act.
They'll take those.
Later on, what happened, in 2015, they say that that tax is one thing. We impose an additional tax. Now, this additional tax, you are liable to pay the tax.
I'm not denying.
No. The moment you are liable to pay the tax, you are liable to register. You have not registered yourself.
Yeah, still willing to raise them, my lord, only.
No. I'm not on that. Now the question is, you are liable to pay the tax, which you have not paid.
Correct.
So now they say, there is a communication issued by the Commissioner of Taxes that look here, these people have not registered.
Yes, my lord.
And unless they are not registered, the problem for the tax authority out here is
To identify me.
that you are to catch hold of these people as unregistered dealers. So they have to apply different procedures.
Slightly, my lord, I would just like to come on a different footing here, man, because an effort was made by the excise department to transform and to convert our license into off licenses. My lord, a treatment was given to similarly placed license holders just few years back, and there was a gadget notification and rules were changed. I'll come to that rule, my lord, wherein we were given a one-time option. They took, my lord, the application fees of 2 lakhs each from us, and we were recommended by the district commissioner by saying that the inquiry was made, your case is a fit case for conversion. Now, that application being lying pending, my lord, it was recently that communication be received. And then, my lord, this interim communication comes into play. Now, my only humble submission is that we have arguable case because, my lord, this parity of treatment, they cannot just wish their hands off by saying that your license has not yet been converted, my lord. Because once a class is created by them, I'm not seeking to be created by my own, my lord. By statute, a class has been created. We were given, all rural IMFL shops were given this option, you go and you convert it and become off license. Because they had some policy matters, my difficulties in running this on license in rural areas. So conscious decision was taken. We applied on time. Now we are waiting for that particular thing to come and become fruitful. At this end, at this juncture, my lord, they come and impose us this thing. But we will register it, my lord. Even if we are off license tomorrow, we can register. And the consequences of me having any area and everything.
No, off license is not required. This additional tax is not there.
But the area that we have, my lord, if they identify us, area they can always invoke. The moment we are off license, the area that I meant to pay, my lord, they can always, my lord, give us demand subsequently.
You register? Go and register first.
My lord, we have filed a, my lord, we have approached them, my lord.
No, first get yourself registered, then they will do it.
Yes, my lord, we will.
Have you got yourself registered or not?
My lord, no. Till date, my lord, we haven't yet registered because.
Registered. You have not registered. Why? You see, it is the mandate of law you have to be registered. You see, that amendment has not been challenged. Where is that amendment? Yeah.
My lord, they can come.
Where is that sales tax amendment?
This is the, may I just?
You have not enclosed also.
No, I have written the part, my lord.
I don't allow this time, Mr. Puraboy, you to withdraw also. Because allowing you to withdraw has caused me more trouble. Yeah. This is this. No, kindly see. No, I'm saying this. This is not one. This one, 30th of September.
26 August 2000.
No, 30th of September 2015. Kindly see here.
Yes, my lord.
Amendment of section 10.
Then, my lord.
Notwithstanding anything contained in this act,
The retail online.
the retail online license for portable liquor mentioned in the fourth schedule except countries shall pay output tax on sale made by him at 6% without any set-off of the tax paid on the purchases made from the bonded warehouse in the state, subject to the condition that the such portable are purchased locally from the bonded warehouse of the state.
Absolutely.
Now, because of this, you become liable to
For-
pay certain tax. Now, kindly take up the VAT Act. That day also I produced this. There. Mr. B. Gogoi, that day I should have disposed of his matter. If I had disposed, this problem would not have arisen. You kindly come to section 22. No, 21.
21, my lord. 21.
No dealer shall, while being liable to pay tax, carry on the business as a dealer unless he has registered and possesses a certificate of registration. Now, it is required on your part to have registration.
My lord.
Then,
But there is
now,
it-
no, Mr. Buragan, kindly listen.
my lord.
You get yourself registered.
My lord.
Now, whether they are, because you see,
My lord.
the question of payment of tax is also another thing. The tax will be on the basis of a demand.
My lord. You will make.
You will register yourself, but the question is they have to demand.
Yes.
Now, is it a case of escaped assessment?
No. Well,
Kindly come to section 36. Audit, escape, what is escape? How much? 40, 40. Where 40, section 40.
Turnover.
Kindly come to section 39. No assessment under the foregoing provisions of this act shall be made after the expiry of 5 years from the end of the year to which the assessment relates. Meaning thereby, from 2015 to 2020, for this period, they cannot do anything.
Correct.
So you take care of that. Now thereafter comes 40, escaping. Whereafter a dealer is assessed under 34, 35, 36, 37, who is assessed, remember, of this act, for any year or part thereof, the prescribed authority has reasons to believe the whole or any part of the turnover of the dealer in respect of any period have escaped assessment, which will also include non-filing of self-assessment. Isn't it, Mr. Gogoi?
Well, yes, madam.
I had delivered a judgment on that aspect also.
Okay.
No? It will include also self-assessment. So if you fail to file the self-assessment also, it will include. But this can only be exercised only for what period?
8 years.
8 years. After the expiry of 8 years from the end of the year in respect of which. So under such circumstances, as on date, there is no dues. They have to make a notice of demand.
Absolutely. Correct, madam.
But the fact that you have to be registered is not an issue. You have to be
We
registered.
will register, madam.
Then what is your case?
Only thing is that the kind of, madam, the way they have come that they are saying in the impugn communication that they will not renew our licenses, madam. My only respectful submission is that, madam, the question of renewal, my licenses will come into play, madam, in just, madam, in the month of February, madam. On 15th of February, I need to submit my renewal proposal, madam. So like, I'm having this apprehension, madam, if this be the ground that if I, after registering also, if they, and after maybe.
Mr. Buragoi, you make this submission that look here. Even if when I have registered also,
Madam,
there shall be due when there is a demand.
exactly, madam. Okay, I got,
There is no demand.
there's no demand.
So there is no dues. So the third condition is not met. But the fact remains that you have to be registered.
Then we'll duly register, madam, and in.
But I can't allow you to withdraw also. Because if I give you file a recall and get Mr. Kane Chaudhary.
Pass an order, madam, allowing me to register and then due protection.
NJ Khaton here, Amarjit Borman.
That too he has gone. Because he was having the problem with 15. He has only one. But the problem with Mr. Buragoi is this. I asked him to withdraw one petition and then I am facing a lot of trouble. He is filing application after application for recalling and all. And this matter is going on. So therefore, I cannot allow him.
May I just take my lord for a moment to one, madam, gadget notification, wherein, madam, he has been given this chance to convert, madam, if my lord may allow me. to-
I know. You see the rule I know as per I think 294 or
279A.
279A. 279A, if you are in a rural, you can be.
Correct, madam.
So therefore, you get yourself registered and I direct him to consider
Madam.
that application because it is the mandate of law for them to consider. Now, while considering, you can very well say that there is no demand.
Did that mean?
Why should it? But you have to be first registered.
Because at present, till now, they are still on license holder. At present,
No, they have to be registered.
they have to register.
If you cannot come up and say that now they have realized. No, because the law was there in the year 2015 on 30th of year. Because if you see, this act
September.
shall be, it
Come
shall
into
be
force.
deemed and came into force.
15, madam.
It shall be deemed to have come into force on 17th of June 2015.
Correct.
So therefore, this provision is there. And as per 21, you are required to be registered.
Difficulty was what I could learn from the documents. My lord, these things have been working so smoothly, my lord, without any
objections coming from their end also, because they have actually paid the VAT, the prepaid tax in the category of VAT. I may just be able to show your lordship. And they have accepted, and every consignment, every permit that they issue, the VAT has been paid by us. Obviously,
Mr.
it was
Mr.
been
Buragoy, when I was on that side,
My lord.
I was the person who was opposing when there was all these people, all retailer owners. I was appearing for the bonded warehouse.
Hello.
They have two associations. Okay? One was the retail association, one is the bonded. I was appearing for the bonded warehouse association, wherein they had challenged initially the GST Act. You see, in a tax there are various points of sale. More particularly, you find it out there in the Sales Tax Act, as well as also VAT. Also, there are various points of sale, which is very much unlike in the case of VAT. Also, it is unlike so many, but in GST or even in VAT. But nowadays, the question of point of sale is not there. It is every point of sale, taking into account there is a value added.
Value addition to the product.
Now here, what was happening was earlier the point of sale was they used to get it from the retailers. The retailers were liable to pay the tax. Then the problem arose that it was very difficult to get the money. So the government, in its wisdom, or the legislature in its wisdom, amended this section 10 of the GST, not the GST, General Sales Tax Act, 93. And thereby say that the point of sale will be brought to the bonded warehouse.
Okay.
So at that point of time, so the point of sale was there, so you need to make the payment. So now what they have done in 2015, it was then continued under the VAT regime. And then in the year 2015, they say that this you pay. There's an additional
6%.
of 10%. So this you have to pay. Now the problem which will be arising upon you is you have not recovered that.
That is the major problem. Even we have taken this plea from my customers or consumers, and that is the main.
Because at the end you have to recover, but you have not recovered. But the fact remains you have to pay. You should have charged the tax also. Problem there. This thing which looks very like it's what you call in Assamese you can call it Piringoti. Will become a huge fire because it will have far-reaching consequences.
If I go back to 2022, the sale that I have made, although I have to record amount of tax that will come on a shoulder would be unprecedented, my lord. And these are all rural people, my lord. My lord. They are not even running in any profit, what I could learn from them, my lord. So they wanted to convert into off-license, my lord. And state allowed them to convert.
If they are not making profit, then there is no sale. So there is no sales tax.
But they have to fall under that, my lord, of course, my lord.
Yeah.
And I'm obliged, my lord.
Okay, we do one thing. Conversion, we are not going to do it, anything. This communication, we are not staying it. You have to register. What to do, Mr. Gugoi? The additional one? Huh?
Otherwise also, my lord, section 26 says, my lord.
No, he has to. There's no quarrel with that. I'm not staying there.
Non-registration is also there, my lord. Per day 100 rupees. That is the day when the sale, my lord, he has conducted the sale. So 15 to day, there is no limitation.
So you have been given an opportunity to register. Why you're not registering?
Our apprehension.
You have come before this case without registering. Now problem arises there. Once it is registered, I can give that order to that effect that let them consider. Because that is what is being asked. Because you see that they have not made a demand. Once you register also, then you can charge.
May I suggest, man?
Problem arises this now. So you do one thing, you withdraw, register, come back. I passed it for order 79, 279A. No, definitely. I'll give you that liberty to come back after registration.
And if the demand is that will be
That
coming
will be
later on,
different.
because on 15th
You
of
see,
April,
you see, your consideration of the application is for conversion. It's not a case for renewal. Renewal is different from conversion. Conversion is under 279A. It is to be only done in a rural area,
Correct, my lord.
subject to all the parameters being followed, which has nothing to do with non-payment or anything. That was the one time we explained, and this still continues. And there are various orders being passed by this coordinate bench, including me, that these conversions should be allowed. That's all. So therefore, why don't you first register, then come back to this court?
My lord. Or if I may suggest, my lord, if your lordship gives them a direction to consider our representation for conversion, at the same time, we will register.
How can I do it?
Because it's pending, we have made a prayer, my lord.
No, that will have a bigger problem.
Because moment we are into off license.
You see,
that
they
is the
may not do
transfer.
it.
And they also at the right time, they have come with a refused communication because it's halfway done almost. Everything has been done and it has been approved by the deputy commissioner also. Then my license is fit to be converted. I have given a certificate also.
No, then once it is converted, you see, once you register, you convert. I give you the permission because otherwise you are challenging this registration document, na? This document you are challenging number 3.
They may not harm my lord. Only to the extent of renewal part that they have observed that non-registration and non-payment, they are making it two ways, my lord. I have to register and also have to make the payment. Now, without even knowing how much I have to pay, they are saying that your renewal will not be allowed. So my registration today, I don't have any issues. I can register, but the question is how much money I owe them or how much I owe to the state will have to be given to me.
No, for that, 5 years is there already. So they have to initiate for action under 40
Yes, correct.
for reassessment. So therefore, turnover escaping assessment they have to take. Otherwise, they cannot.
The apprehension part of my is that in this process, my renewal will be put to standstill. That is the only apprehension. On 15th of February is the proposal that I do submit. The process that the state would undertake would be.
I'm not asking you not to do it. Your renewal will be there, considered by
Yes,
this
that would
court.
be done. If that is-
But first you register.
Of course, we'll register, my lord.
When?
My lord, immediately any order passed by my lords, I'll convey.
Why should I pass an order? For you to register, you are bound to register.
Yes, my lord.
Later on, you will say that.
No,
this
my
is-
lord, of course.
Okay, we issue notice. Only thing is, if you issue notice, the problem is it will get delayed. You see, the problem is if I issue notice, it will get delayed. On the other hand, if you go to register it, I can direct them to consider. You see, you must be having those orders also. Where Justice Unnikrishnan, Justice Ete, as well as me have passed orders as they are to consider in terms with 279A and to do so within a period of 60 days. That these are orders being passed. So why I can pass that order? But the fact remains today, it appears the flavor of the petition is to get away from the tax liability.
No. Not really for renewal, my lord. It may have the flavor of getting away, but
But why you are making the prayer at number 3?
my lord, that prayer is only in context with the fact that they have hold an opinion that I will not be allowed to renew, my lord. Only to the extent. If your lordship is pleased to pass an order that them renew, I'll definitely go whatever tax is liable to be paid.
No, the question of me passing an order now, I have to renew, and you don't renew it, you don't register it, then what happens? How? You see, they will consider today and make you off. Off is not liable to pay this, but the period is also over. But this act is gone now from 2017.
No, for my lord, liquor it is there. VAT is there for liquor.
No, is this provision there now? I'm saying this. Because 2017, the GST has come.
No, even for after GST, my lord, that this part will remain, my lord.
This part is
Liquor,
there.
Yes, it is there.
But they are. the
Petroleum
items
products
under
and my lord liquor, it is there. Yes.
Liquor
VAT
is-
is there.
So the VAT will apply.
Yeah,
That will apply. That will apply, no doubt. my lord.
So you have to register.
Yes, ma'am, of course. I will.
So if you don't register, how can I pass an order? Tell me.
Then during the pendency, I'll register, my lord.
No, then I can't pass that order. I can only issue a notice.
Then. your
Shall I
lordship
take
will
that
dispose of-
notice?
dispose of.
Huh?
But my lord, you can. It will go to the-
We'll issue a notice. We'll see when the matter comes after in the month of March.
No, but that problem would be again, my lord, in the month of February, our licenses are to be renewed, my lord.
Therefore, the question is you should have registered because your registration is mandatory. Anyways, let me pass an order. We'll keep this matter pending then. But the problem is, you see, I today take up this matter in this manner that my another coordinate bench should not take up in that thing. So then the problem arises. Anyways, take that risk. Anyways, issue notice making it returnable on 6th of February 2026. Mr. B. Gogoi accepts notice on behalf of the respondent number 1, the learned additional advocate general, accepts notice on behalf of the respondent number 1,
1, 6, 7.
2, 3, 5, 5 no.
1, 5, 6, 7.
1, 5, 6, 7, and 7. Mr. R.R. Gogoi accepts notice on behalf of the respondent number 2,
2, 3, and 4.
3, and 4. Full stop. Extra copies of the writ petition be furnished to them by tomorrow. The case of the petitioner herein is that the petitioner was issued a IMFL on license sometime in the year 2022,
At page 58.
bearing registration license number 158/2022. The said IMFL on license was issued in an area falling under NIS Bhekuljan Gao, PO Bhekuljan PS, Tenga Khata, Dibrugarh, which is a rural area. As the IMFL on license was not profitable, the petitioner sought for conversion of the IMFL on license to IMFL off license, which is permissible in terms with section rule 279 capital A of the Assam Excise Rules 2020. 20?
5, my lord. The amendment was.
No. What is that rules? 2016. 16 of the rules 2016, which came into effect with effect from
On 7th of April 2025.
25. Full stop. It is the case of the petitioner that the respondent number 2, respondent number 3 have not considered the same, in spite of recommendation being given by the respondent number 4 and 5.
At page 74, my lord.
Full stop. On the other hand, it is the further predicament of the petitioner that the respondent authorities, the respondent number 3 have issued a communication directing the petitioner to register under the Assam Value Added Tax Act 2003.
My lord. Yes,
Three.
please.
In view of section 10
1.
bracket 1 capital A of the said act, which came into effect on 17/6/2015. Full stop. It is Mr. H. Buragwa and the learned counsel appearing on behalf of the petitioner submits that the next date for that the petitioner's license would expire on 15th of February 2026, and therefore and the respondent authorities have taken this as an excuse not to renew, although there is no quantifiable although no amount of tax have been quantified so far in the petitioner. It is under such circumstances the present petition has been filed. The respondents herein are directed to bring on record their stand by filing the affidavit. Etu 6 দিনৰ আগতে দি দিব notice. But you have a pending the next date, Soma, it shall not be a bar on the part of the petitioner to register under the Assam Value Added Tax Act, if so advised. Full stop. It shall also not be bar on the part of the respondent authorities to consider the application filed by the petitioner seeking conversion once the petitioner is registered under the Assam Value Added Tax Act 2003.
Petitioner is the fair price of for the license holder, your lordship. His license has been cancelled without proceeding the due procedure. Impugned order is on page 25.
Where is the order?
Impugned order is on page 25, annex 4, your lordship.
Then no action taken.
No, your lordship.
Issue notice making it returnable on 7/1/2026. Mr. K. Goi accepts notice on behalf of the respondent numbers
1 to
1 to
Lordship.
5. Why are you making him by name?
Yes, laws and FIR Lordship. That respondent number 7 Lordship. But respondent number 6 is laws and FIR regarding irregularity.
Why are you making him by name?
On his, based on his report, his,
So, your basic case is it has gone beyond the period of 90 days. Why are you making him by name? It makes no sense. Then I can't have a short notice. One to 5. Full stop. For the present, this court is not inclined to issue notice upon the respondent number 6. Extra copies to by tomorrow. The grievance of the petitioner herein is that on 26/6/2025, the respondent number 5 had suspended the license of the petitioner, fair price shop license of the petitioner. Full stop. It is a further case of the petitioner that though the license has been suspended as far back as on 26/6/2025, no steps have been taken in terms with clause 15(2) of the Assam Public Distribution Order 1982. In addition to that, it is the it is also in addition to that, it is also submitted by Ms. So-and-so appearing on behalf of the petitioner that a license cannot be kept on suspension for a period of more than 90 days in view of the mandate of clause 15 of the said order of 1982. Mr. K. Gogoi, the learned additional senior government advocate, shall obtain instructions on the next date as to whether any further steps have been taken in pursuance to the suspension of the petitioner's license on 26/6/2025.
deeply obliged.
What is this?
This is the matter where I'm challenging certain decisions that were taken by the respondents, where the allocation of food grains that takes place under the NFSA, there's a total of, I think, 16.95 metric tons, lakh metric tons of it. A portion of it is being diverted to the tea garden management. That is and to give effect to this diversion, minutes were held. Detailed procedure is now being laid out. I'm challenging those minutes and the procedure that they're proposing.
Where is it?
Page 53 on as well it starts. Connected. The relevant decision, the full minute I think would be relevant, Your Honor, but the impugned decision is at page 56. It says after threadbare discussion on all aspects of the issue, the following decision was taken. On page 56.
Where is that relevant decision?
Your Honor, page 56.
Where is the relevant decision?
The decision is at page 56. After threadbare discussion on all aspects of the issue, the following decisions were taken. So the decision is what, if Your Honor may permit me to read. The whole decision is what I'm impugning because it lays out a mechanism which is completely ultra vires the NFSA and the TPDS.
Where?
So the projected quantity of 3,526,723 lakh metric ton of tide over wheat to the state after addition of new beneficiaries will not be sufficient for distribution to all the 2.51 crore approximate of NFSA beneficiaries. As such, it will be more prudent to concentrate the allocation of 3,523 lakh metric ton of tide over wheat to the ration card holders of the tea garden areas. Honorable Minister FPD and CA instructed the department to devise a mechanism/scheme for the same. So this scheme is what I'm essentially challenging. The chair suggested that the proposed scheme shall also take into consideration the present ratio of allocation of 8% to BTC area tea garden and FSA beneficiary. Out of the remaining quantity, that is 92% of the tide over wheat, which will be around 3241.825 metric ton as per table A column 4, still in page 53. Allotment of 3,000 metric tons may be considered for the tea garden management/association. So allotment, as per the request received from the Indian Tea Association for distribution amongst their workers who are ration card holders under NFSA. The balance 241.825 metric ton shall be available with TC for distribution to NFSA beneficiaries living in tea gardens who are not workers of tea gardens, and this quantity shall be distributed through the existing fair price shops. Subsequently, even though the request received from the Indian Tea Association for additional allocation of 4,500 metric ton of tide.
What has happened to the matter filed by Indian Tea Association? It's given here, na?
This is the letter here. I've annexed the letter. This is a representation on the basis of.
No, the Sam also challenged the order passed by the Assam whereby a long existing practice of allotment to tea
Yes.
laborers was discontinued on the basis of direction.
Actually, may I give some
Due
context? here?
consideration of the case projected by the petitioner, the court stayed the government notification. Following the interim order, the allotment of so and so continued as per the earlier system.
Yes.
Accordingly, where is that petition?
Your Honor, the relevant orders,
Where is this petition?
I filed the relevant orders. Your Honor will find it.
Is it pending? Is it pending?
No, it's not pending. This has been disposed of.
How?
The petitioners in that writ petition 6. So what happens is when the NFSA comes into is about to come into is about to be enforced under around December of 2014. 2014. A letter is issued by the central government. Your Honor, first start with this letter because it's actually the modus operandi that's at play here may actually become clear from here. 23rd of September 2014 at page 76. May I read, Your Honor?
Not here.
And the stay order gets vacated at page number 104.
No, what has happened to this writ petition?
At
This
page
is,
104.
huh?
They withdraw it, effectively saying that no grievances subsist. They say no grievances subsist. So writ petition 6 is where the stay is given, that gets withdrawn. The entire basis of the additional allocation actually goes with it.
And what is the grievance of the Assam Sah Mazdoor Sangh? Huh, Mr. Naik?
That I am not.
What
aware.
can be the grievance of the Assam Sah Mazdoor Sangh in view of the targeted control order of 2015, wherein it says that it has to be, food grains will be given from the corporation and it will be given to,
No, that scheme is already there. The management of tea gardens providing rations to the laborers from their own procurement, Lordship. It is not from the PDS, Lordship. They procure they acquire the same from the FCA godowns and distribute it among the laborers. That is a different scheme. With that scheme, Lordship, this has no connection. Here, Lordship, this is the tide over wheat, Lord, if he has concluded already, Lordship.
now tell me.
Tide over wheat, Lordship. We collect rice and wheat from the central government. If the consumption of rice is less, Lordship, for the remaining amount, that tide over wheat comes, Lordship. It has a correlation between the two, Lordship. Now, in this meeting, Lordship, although this minutes has been silent, no such decision has yet been taken. If Lordship comes to the minutes, Lordship, it starts from page 53. And the relevant portion is at page 56, what now my friend has just now read, Lordship. Lordship, if Lordship comes to the page 56, fourth paragraph. Third line, Lordship, as such, it will be more prudent to concentrate the allocation of 3523.732 LMT of the tide over wheat to the ration card holders of the tea garden area. Honorable Minister FPA and CA instructed the department to devise a mechanism scheme for the same. 8% for BTC if Lordship comes to the next paragraph, Lordship.
So this has nothing to do with the targeted control order.
That is a different issue, Lordship.
That is not under the NFSA.
No.
That is under NFSA. This is not under NFSA.
This is under NFSA, Lordship.
But that is also under NFSA.
No, that is entirely by the management. Here, Lordship, what has been proposed from the tide over wheat, Lordship, a certain portion will be given to the tea garden management for distribution among the laborers, but it will be under NFSA. What he is apprehending that from the fair price of owners, it will be, that business will go to the, it will not be business actually, but that portion of business will be, no longer will be with the fair price of owners. That is what they are apprehending. But what is I am submitting at this stage, Lordship, this is only at a very preliminary stage, Lordship. No final decision has yet been taken. If Lordship comes to paragraph 1, 2, 3, 4, 5, 6 of page 56, out of the remaining quantity, that is 92% of the tide over wheat, which will be around 3241.825 MT as per table A, column 4.
So you are saying that this act, this thing which has been done, this minutes, have
this
not
is
been
only
given
a
effect to.
discussion, Lordship.
No, it has not been given effect to.
Lordship, that is why I am showing, Lordship. In that line, Lordship may be considered. Next paragraph I give may be allotted. If Lordship comes to the page,
No, Mr.
page 58.
You have to tell me whether this decision has been given effect to or not.
No, page 58.
Okay.
Last
don't give
paragraph.
Effect to.
Page 58.
Don't give effect to.
Page 58, Lordship.
Now, if you are saying that the petition is premature,
Lord, page 58, one
Yeah.
paragraph only, last paragraph. Once the proposal is approved by the competent authority, the same shall be placed before the Honorable State Cabinet for further approval. In the Cabinet memorandum, the views of the Labor and Welfare Departments are to be incorporated. So this is only a view taken by the Labor and,
but it has not been given effect to.
no decision has yet been
Now,
taken.
has it been placed before the cabinet?
Not yet, Lordship. It's, today morning I talked to the department, Lordship, they said no, nothing, no steps, no cabinet has not yet considered. So Lordship, let him come at an appropriate stage, Lordship. Let a decision be taken by the government. Only then, Lordship, his grievance will,
This entire process, Your Honor, is absolutely illegal.
No, but illegal or not, that illegality has to happen. It is in still pen and paper, not come into the real act. So therefore, you come later on when they take, the cabinet approves. Now what is there? It is only a discussion. If any change, is it your allegation that this tide over wheat has been allotted to the team management?
That is what they intend setting out to do, because the team management, what they say, let me just summarize this. Your Honor. What they're saying is that so first allotment takes place under 3 heads in Assam today. The first is the normal allotment that comes for the eligible beneficiaries. If there is a shortfall, then under section 3, 3 subsection 1, second provision, there is a provision for tide over allocation it's called. Now that can be wheat or it can also be rice. Now that is to make up the gap, and there's a calculus that's applied, which is the average of 2010 to 11, 11 to 12, 12 to 13, the average allocation that was made pre-PDS, pre-NFSA, that allocation is calculated, and it's seen whether there's a deficit, and that is made up by this tide over allocation. And the total, both these allocations, the regular and the tide over, is towards the beneficiary. There's no dispute there. And that is covered under Schedule 4 of the NFSA Act. Now, once the tide over wheat comes, it has to be distributed through the normal channels, through the PDS system.
The targeted order will
Yeah.
come into play.
Absolutely. And that clearly prohibits any diversion, any.
But still, this is at a nascent stage. The cabinet has yet to approve that. You are challenging only in minutes.
Yes, Your Honor.
Then,
Apprehending that once this actually starts coming into force, then it comes, because actually the team.
no, if it comes into force, it's okay. You are challenging these minutes. The minutes has not yet been given effect to. Why should you come now? Apparently it has not come, and because what will happen, Mr. Das, later on is, once that it is approved, you have to again file another writ petition. Because the cabinet's approval is a different approval compared to what is approved by the department. It is a proposal being placed to the cabinet. The cabinet once approved, you have to challenge it independently. So it has no meaning.
The entire exercise then will have to be vitiated because they get selling the tea to the tea garden.
The cabinet has to take a decision on that.
Very well.
Cabinet has not yet taken a decision.
Then they may be directed to at least proceed as per the NFSA and not outside the.
That is not your prayer.
Taking the washing of this.
A quashing of a thing which has come in, is yet to be born. It's still in the embryo. Well, no concluded right. Chalo. Heard Mr. DJ Das, the learned, withdraw, dismiss.
Good.
Heard Mr. D. Das, the learned counsel appearing on behalf of the petitioner, and Mr. P. Naik, the learned additional advocate general, Assam. Mr. P. Naik, the learned additional advocate general, Assam, that the instant writ petition is premature, taking into account that the petitioner have only challenged the impugned minutes of the meeting dated 6/9/2025. First of the learned additional advocate general further, referring to the impugned minutes dated 6/9/2025, drew the attention of this court to the last paragraph of the said minutes.
$58.
Wherein it is seen that wherein the learned counsel additional advocate general submitted that the proposal has to be approved. Proposals which have been mentioned in the minutes is yet to be approved by the competent authority, and thereupon would be placed before the honorable state cabinet for further approval. He therefore submits that the instant writ petition is premature. Mr. Didas, the learned counsel appearing on behalf of the petitioners, submits that taking into account the said submissions made by the additional advocate general, that no such decision has been taken to implement the the proposal mooted out in the minutes of the meeting dated 6/9/2025, the petitioner would not like to press the instant writ petition. However, liberty may be given to the petitioner to again approach this court when the proposal is made effective. So taking into account the above, the instant writ petition stands closed on withdrawal. However, liberty is given to the petitioner to again approach. The closure of the instant writ petitions, however, shall not prejudice or preclude the petitioner to again approach if the proposal so mooted out in the minutes, impugned minutes of the meeting dated so and so is made implemented. It is on the question as regards section 99 of the Motor Vehicles Act, whether a scheme is necessary or not. Yes, where you were showing the affidavit in opposition yesterday.
Lordship. Yeah, happy to be here. Lordship, may kindly take up the affidavit. I'll take your lordship to the resolution dated 2012-2024, my lord.
Page
At page 135, my lord.
125.
135, my lord.
135. Yes.
Lord, this was the resolution dated 2012-2024, where, my lord, the decision was taken. Kindly come to decision at page 136, my lord.
Yes.
Serial number 3, my lord. It starts at page 137. A suggestion is as suggested by the MD ASTC and recommended by the DCP Traffic, Guwahati, the Honorable Chairman RTA Kamrup directed the DTO Secretary so-and-so to explore opportunities in gradually phasing out of the diesel-operated city buses plying on city bus route number 23, Khanapara to Dharapur via Ganeshguri flyover, and route number 36, Basishto Mandir to Dharapur via Paltan Bazar, so that by January 2026, only electric buses could ply on these two routes, aligning with sustainable and eco-friendly transportation objectives.
Where?
Page
See-
137, my lord. Serial number 3. Serial number 3, Green City Bus route, as suggested by the MDSTC and recommended by the DCP Traffic, Guwahati, the Honorable Chairman RTA Kamrup Metro directed the DTO and Secretary RTA Kamrup Metro to explore opportunities in gradually phasing out of the diesel-operated city buses plying on city bus route number 23, so-and-so to so-and-so, and route number 36, so-and-so to so-and-so, so that by January 2026, only electric buses could ply on these two routes, aligning with sustainable and eco-friendly transportation objectives. This was resolved on 20th of December 2024, my lord. Then kindly come to the next meeting at page 141. 5/4/2025. 141. It starts at 141. The relevant resolution at page 144. my lord.
Yes.
144. resolution number 2. Designation of city bus route number 23 and 36 as green routes and renewal of stage carrier permit of diesel operated buses plying in Kamrup Metro. In this regard, the ATC Assam and the DTO and Secretary RTA Kamrup Metro informed that as per resolution number 10 of the RTA board meeting held on 2012-2014, the MTAG has submitted an affidavit seeking withdrawal of the Honorable High Court writ petition number so and so. This is the petition already they have withdrawn. The following decision as to allow the remaining 46 buses as so and so, so and so. Next paragraph, my lord. The DTO and Secretary RTA Kamrup further informed that approximately 169 diesel operated buses, including 19 out of 46 above mentioned buses are currently plying on.
So these decisions are being taken by whom?
By the RTA, my lord, Regional Transport Authority.
So under what power?
Regional Transport Authority, Lordship, the Transport Authority is
It is not
defined
the state government.
under Section 68 of the MD Act. Under Section 68 of the MD Act. They are the authorities, my lord. There are two authorities defined in the Act. 68, my lord. The state government shall by notification in an official gazette constitute for the state a state transport authority to exercise and discharge the power and functions specified in subclause 3 and shall in like manner constitute regional transport authorities to exercise and discharge throughout such areas. The regional transport authority is for a particular area and state transport authorities for the state.
When we come to 68(3),
68. Lordship.
the state transport
This trend-
authority and every regional transport authority shall give effect to any direction issued under section 67.
Lordship. And the state transport authority.
What is 67? Power of the state government to control road transport.
Yes.
This is power.
Yes, my lord.
What is the government having to advantages offered to the public trade industry by the desirability of coordinating road and rail, desirability of preventing deterioration of the roads, promoting effective competition among them may from time to time by an official issue directions both to the so and so and so and so regarding the passengers, convenience, economically so and so, so and so. So this decision can it be taken by the regional authority?
Yes, my lord.
Because you see, kindly come to 68(3)
Yes.
CA. Government to formulate rules for plying stage carriages. To
Lordship.
perform the duties of the air where there is no such authority to settle all disputes, decide all matters on which differences of opinion arise between so and so, discharge such as may be prescribed. Now, these authorities, the state and the regional, are bound to do so. But wouldn't this come within the ambit of the powers to be exercised by the state under 67?
Well, ultimately, the power under 67, the state government power, ultimately, these are the transport authorities under section 68. So
Maybe.
through these authorities.
But how do you take care of? Because you see 68(3) says, the state transport authority and every regional transport authority shall give effect to any directions issued under 67. Now, 67 is the power of the state to control road transport. That means the power is not with you, it is the power of the state government. What do you say, Mr. Mahanta?
Yes, Malad, absolutely, that's why I fully agree to your lordship. RTA board has no authority on this matter.
Because this is all being done by the RTA.
Exactly, RTA board has done it. Regional authority.
It's a different thing. 99 may not apply. But isn't it the authority of the state to do so?
They cannot.
Because it is the state government's decision. Look here, for convenience, all these things, we are going to make it a green route.
No, Malak, my friend has placed it. It is because the transport, state transport, what they say, MD has made a proposal. 137 Lordship has read it. As suggested by the MD ASTC. At page 137. Green City Bus routes. How does the question come? That is how it has come. What you have seen, column 3, Green City Bus routes as suggested by the MDSTC and recommended by the DCP Traffic Police.
Well, they are members of the regional.
They have noted this proposal because of this suggestion given by the MDSTC. For their benefit, the Honorable Chairman RTA Kamrup Metro directed the DTO and Secretary RTA Kamrup to explore opportunities in gradually phasing out the diesel operated buses flying on city bus.
Show me the RTA has the power to do that.
They can just regulate.
It is not even the state or transport authority. You see, who are there? It is not the state transport authority. It is the meeting of the special RTA board.
Yes.
Well, regional transport authority is an authority under the act and the rules.
No, RTA is also the authority under the act. There are two authorities. The state transport authority will be for Penn,
entire
it is
state.
the Penn state of Assam.
Yes,
Whereas the RTA will be too exclusive to the areas.
for the region.
So these RTAs may definitely have the jurisdiction in this area, but do they have the power to control the transport, the road traffic? You see, the power to control road transport, a state government having regard to the advantages offered to the public, which means breathing good air, transport and industry by the development of so-and-so, desirability of coordinating road and so-and-so, may from time to time by notification in the official direct issue to both so-and-so regarding the passenger's convenience, economically accommodated rates. Any direction under one regarding fixing of fares and so-and-so, contract carriages for so-and-so contract and goods carriages may provide that such fares so-and-so shall be inclusive of the tax payable by so-and-so, so-and-so. That the state government may subject to such condition as will be deemed fit and with a view to achieving the objectives specified under D, promoting effective competition, or they are relaxed all years. Notwithstanding anything in this act, the state government may by notification modify any permit issued under this act or make schemes for the transportation of goods and issue so-and-so, or efficiency and last so-and-so, 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 promotion, enhancement of the environment. See, protection, kindly
Yes,
see.
yes, Malak, I-
67(3).
I is there. I is there.
Protection and enhancement. So
Yes.
your green route is on the basis of the state government's decision.
Yes, Malak, Lordship may kindly also take note of subsection 4 and 5 of the section 68. 68.
For the purpose of exercising and discharging the powers functions on the three state may subject to such RIA or RIA issue directions to the state and so and shall in discharge of functions under the act give effect and guide. And so if authorized in their behalf by the rules made under section 96 may delegate such power or so authority to such regime. But I'm not on that. But it is
So the-
absolutely the prerogative of the state.
No, Malak, my respectful submission is that is an issue Malak now cropped up. The entire Malak since 2023, in my affidavit, Malak, we have said that since 2023, the RTA from time to time has been taking various decisions. And it is the government, Malak, they have authorized the.
Mr. Nath, you have to understand. Any authority may take many action. There's no quarrel with that.
But-
They may take many things, all these things. But whether they have the power to do it in view
Yes,
of
Malak, under
section
section
67(3).
68(4), the government has given the power, Malak.
Where?
Section 68(4).
No, this is reserved for the state. Notwithstanding anything in this act, the state government may by notification in the official gazette modify any permit issued under this act or make schemes for transportation of the goods and so and issue licenses under the scheme for promotion and development and efficiency in transportation, which includes the protection and enhancement of the environment. So it is to be done by the state government by way of an official in the official gazette. So
But-
this being not done, that can be then these directions which is being given in the official gazette have to be implemented under section 68(3).
Well, under 68(3). No, under 68(3), the power is given and the government has delegated the power to the RTA. RTA has been constituted as per rule 42 of the Assam rules.
Mr. Nath, kindly see, notwithstanding anything contained in this act, the state government may by notification in the official gazette, where is that?
But we are on the power of, Lordship, on the power of the RTA. Whether
Yes.
RTA can act on that. The RTA is an authority constituted under section 68.
But
And
can
under
the
section
RTA
68(3).
touch the permit on the ground that we want tomorrow to make it green route, if it is not the decision of the state government? My question is to that specific.
Lordship may kindly take up the affidavit, my affidavit. The
No,
paragraph.
no, your basic idea is green route is gone. We state, good. I think we'll hear this after vacation properly.
Well, para 5, page 120. The cabinet has taken a decision. Pursuant to the cabinet decision, this has been done. Kindly take page 120.
Page
120 of my affidavit.
120?
Page 120, 120 of the affidavit.
Yes.
The cabinet meeting held on 28/2021. In the meeting, a cabinet resolution was taken to undertake steps to make Guwahati free from carbon emissions. The extract of the cabinet resolution is we have reproduced, and the minutes annexed to there. And that minute we have annexed. Lordship will find the minutes at page 132. Manoj. Either one.
So then this is for entire thing. Stop all buses if we are to implement this.
This was in 2021. Phase wise, Manoj, we are doing it. That is why, Manoj, in phase wise, Manoj, in phase wise manner.
But
we are
where is
doing
the
it.
official gazette? Where is it notified in the official gazette? My question is that. This can be done, no problem. The state government can do so by publishing it in the official gazette. Where is that?
Well, kindly see the power of the Regional Transport Authority under section 72(22), subsection 22 is there. They can modify the permit. Lordship, we are on the power of the
72?
section 72,
Yes.
subsection Roman 22. It says, Malad, that the Regional Transport Authority, it is the RTA, Malad, they have the power to issue the permit, and the Regional Transport Authority may, after giving notice of not less than 1 month, vary the condition of permit, attach the permit further conditions. So the power is there with the RTA.
So it is not on, you are doing it on the basis of this, nothing to do with green route.
Malad, that is why, Malad, I have taken your Lordship to page 144, the decision which we have taken on 5/4/2025. Let me read, Malad, for a moment, Malad, page 144. The decision, I have read the first part. Kindly allow me to read the second paragraph, Malad, the entire resolution, Malad. What we have done,
140?
144. This was the resolution taken on 5/4/2025. But we have said the relevant resolution is to renewal of stage carrier permit of these buses shall be granted on a 6 months basis, similar to the process of diesel operated buses on other routes. However, the validity of permits of buses operating on routes number 23 and 36 must not be extended beyond 31st of December 2025. The DTO and Secretary RTA Kamrup Metro shall entrust strict compliance with this deadline. The DTO and Secretary RTA Kamrup Metro shall immediately arrange a meeting with the MTAG to inform them of this decision. The objective is to explore alternative routes for the buses post 2025. The bus owners may also be encouraged to switch to CNG or electric buses in order to continue operation on Route 23 and 36 beyond 31st of December 2025. So, my lord, our decision was that we will allow the buses having CNG and electric mode will run on route number 23 and 36. We are not stopping anybody, my lord. We are not cancelling them. And we have in fact taken a decision to encourage them that
Where is that? How will the
Serial number-
renewal of BR for the bus
serial
shall be
number-
granted for 6 months? Validity of the buses operating on years shall be ensure strict
Yes.
compliance with the deadline.
the DTO and Secretary
Decision, the
RTA.
objective is to explore alternative routes for these buses. Post there, the bus owners may be encouraged to switch to CNG or electric buses in order to continue operations on demand beyond so and so.
Yes.
Okay.
My lord, then after that, my lord, another meeting was held on 5/7/2025. 5/7/2025, Lordship will come to page 153.
Yes.
Serial number, my lord, page 153, serial number 8. Representative of the MTAG, the petitioners were also.
Real number?
My lord, the list of persons who attended the meeting at page 153, serial number 8, list of representatives of MTAG and city bus owners of route number 23 and 36 as per NHRA. They were also there, my lord. Permit validity restrictions we have mentioned. Then, my lord, serial number 3, page 154, interactive session with MTAG and city bus owners. Then conclusion, serial number 4, my lord. Finally, Srimati So-and-so stated that this initiative is expected to enhance the quality and sustainability of public transport and will serve as a major step towards creating a cleaner and more environmentally responsible transportation system. Srimati So-and-so concluded the meeting by thanking all participants and urged everyone to cooperate and work collectively towards successful implementation of the initiative to designate route number so-and-so as green routes by 1st of January 2026 in accordance with the resolution number 2 of the RTA board meeting held on 5/4/2025. Then, Lordship may kindly come to page 162, my lord.
So give them some funds. Give them funds for conversion. Make them conversion kit. How many buses are there? 100 buses in that route.
The total as per my.
167, 5 lakhs each. How much? Not much.
No, they are bus owners, my lord. 158 out of
How much?
158.
How much is the conversion rate?
No,
Out of which 25 has already gone.
36
Remaining give them.
36 has gone.
Gone. So remaining give them from financial, so they let them have it.
That is a
You cannot,
right.
because their livelihood is also question. Let me come back at 2.
No, we have not stopped them. We have not stopped them.
No, you have not stopped them. One fine morning, because of the fact that you have got 100 buses, so now you don't want anybody else.
No. That, my lord,
Where will these people go?
my lord, 10 options we have given. 10 routes we have given. The options are given to them. 10 routes are shown to them. in the notice itself, page 187 of that writ petition, we have shown that these are the 10 routes. You can have the option of these 10 routes.
Chalo, let me come back.
Lordship.
Yes.
Malad, we had sought for the upgradation of the matter because our learned senior Mr. Chaudhary had to travel outstation in the second half. Now, my lords, may I request that matter be taken up at your earliest convenience after the opening, my lords, because he has now traveled to.
My learned friend also come from Delhi and we were prepared for the matter, my lord.
Be a
Anyhow,
lord's
they are taking time. They are taking time, my lord, but otherwise we were ready with the case.
Okay, you argue.
No,
Then
no,
your
I-
learned friend need not come next time.
no, no,
He
that's-
will come, isn't it?
My lord,
Don't
one
worry,
sec.
we'll hear you.
No, it's not that, my lord. I'm
No,
just-
no. They should not be like this, that it is because of the court's fault
No,
it has
that is-
happened. That the learned friend cannot come again.
No, that's
Court.
not my idea, my lord. That's not what I'm saying.
Well, take up the matter when it is. I will accommodate you, don't worry.
Very good.
But we'll take up the matter.
Very good.
Mr. Monta, I was thinking, in the meanwhile, apply for your quota lot out there. I will have it on 8th of January and make this decision. Your applying is without prejudice. And we need to hear this because we cannot just pass an interim order and then keep everything at standstill. We'll have it on 8th and we'll finish it off. Let them come up and file whatever they want to file. And I will keep this decision of theirs subject to the outcome on the next date. We'll fix it.
Suspend it till then at least.
No, then again the
No, no,
problem
no.
arises. Again the problem arises.
Saying this, while I'm saying this, Lordship, can you see?
No, Mr. Mohanta, you have to understand. Let's see the balance of convenience.
Yes.
What is the inconvenience to you?
No, because now if we are suddenly shifted out, it will affect
How?
our livelihood.
How?
definitely. Because they are pushing us by force.
No, you were allowed to run in a particular route. Now you have been asked to change the route some other place. How will it affect your livelihood?
Well, firstly, we have a right to continue in these routes unless they proceed in accordance with law. They are
We will
not-
consider on the next date on that, whether it is in accordance with law or not.
Till then.
Here we have to
MRPC
look in.
Lordship has seen it.
No, Mr. Mohanta.
I will say.
No, what is the balance of convenience?
The convenience is that if those 100 buses they are bringing in,
No, their livelihood is not being taken away. They are being asked to apply in some other route.
now we will have to again arrange everything separately.
There's nothing out there. What is the separate arrangement?
Road specific finance was granted to us. And accordingly, it was considered.
Where is the document? That route specific, the finance is being granted? Show me that.
Statement, all those are not.
No, then you can't make that submission, Mr. Monto. My question is, you have to say that your finance would be taken away if you are not in that specific route. Show me that document. I will stay it then. The finance is being granted only subject to the consideration that you are in that specific route.
My contention is that they have assessed it that this much of income will be fetched from these routes. A bus and accordingly insurance and all dues will be there. This is how they have assessed it and they have granted. They have granted
Where is it?
page 109,
Of your,
Given
which,
one document.
which writ petition?
7/6/7/260.
109.
Otherwise, how are they going to be affected?
But they are going to, yes, where is it?
They will be procuring those buses, phase wise.
No, where, no, this is a permit.
This is a permit.
This is a permit which is there.
It is, down below,
Yes.
yeah, three,
Your permit is up till 31st of December.
that's Indus Bank Limited.
Where?
Indus Bank.
Yes.
Indus Bank Limited. We are on finance. Number of persons.
No, no, is it a condition of your finance being granted that you are going to run in this specific route? No, you will get your permit renewed out there. There's no quarrel that your permit is otherwise expiring on 31/12. Page 109 is expiring on 31/12.
Some are, but not all. Not all. Not all. Some are, but not all.
Just for example, the 110, it has already expired.
Okay, express, they have by force.
111, it has expired. 112 is expiring on 29th.
105.
One zero five is expiring on 2nd of May 2029.
29. All the sample we have submitted. This is how some have already expired. They are.
This is route code 189. Route code 189 is different.
Khanapara to Dharapur. Route details from to Khanapara to Dharapur. Via Ganeshgiri flyover. Upper. That is, this is.
Now, why are some permits only for 3 months and some permits are for 4 5 years?
Earlier case was. That how can they impose arbitrarily these term? And they are charging almost the same amount which is charged for 5 years. My earlier petition. That should be stopped. Then Lordship issued notice. They have come up with the affidavit, we have replied to it. At that stage, it is lying. Now they have taken this decision. So kindly see, Malad, this is out and all their.
No, they will renew it in other routes.
Yes. We'll have to submit it.
No, you will submit, they will renew it.
To submit.
No, we'll take it as the undertaking that they will give the renewal in respect to other routes.
No, Malad, other routes, I am not on that for the time being. Ultimately, if your Lordship says that I have no case, then of course, better will be different. But. Yes. Annexure 562, Lordship may kindly Karu. Other case. 6117, we have given the entire buses list.
Page?
Annexure 5.
Page?
Page 62. Page 62, Lordship. Annexure 5, in page 6117.
6117 information, page 62.
Yes.
All these vehicle numbers, owner's name, permit validity. These are 1 is 23, 12, 19, 2, 20, 25, 27, 27, 28, 28, 29. You have given in details, all that. Twenty-six, 27, 29. But the estimate was made that this route will continue. And we are ultimately bound if they have acted legally and they oust us in accordance with law, giving us hearing, all that. Who can stop them?
You want an order?
Sorry.
Okay, let me give you an order.
Because
You are
otherwise,
not bound.
otherwise, by a full submission.
It's
to you,
okay. I
way-
gave you an opportunity to get this order by which they are going to renew without prejudice to your rights. You can apply. And this court will consider on the next date on 8. But if you are willing for asking for an interim direction, I reject it.
Lordship
Go
will
to the
not be-
division
no,
bench.
sir, in that case, Lordship will do one thing. Those in respect of which. the
Mr.
permits are still
Mr.
prevailing.
Mohanta, no heavens is going to fall upon these people. Once it is being renewed, no heavens is going to fall. First of all, there are people whose permit validity is even prior to the writ petition being filed, it has expired.
Some of them,
Then
at least those where the
Huh?
license period is.
kindly
60
see
days.
this, just for example, at page 63, item number 40, person at 43. These are expired on 4/9/2025.
They have extended it 6 monthly basis up to 31st. After 31st, it's there. They are extending it 6 monthly basis, 3 monthly basis.
Now,
4
this
monthly basis.
annexure 5 has been prepared by you.
Those are to give the, how the period, how it's expired, of which are prevailing still now.
Okay, take that
Therefore,
order.
Lordship, there can be see one thing.
No.
At least those were like the permits were.
Leho, heard Mr. K.K. Mohanto, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioner. Icon 6117/2025. And Mr. D. Nath, the learned senior, additional senior government advocate, and Miss M.D. Bora, the standing counsel of the transport department. Full stop. In the instant petition, the petitioner have assailed the actions on the part of the respondent authorities have assailed the decision, the resolution number 2 of the RTA meeting dated 5/4/2025. Full stop. This court had passed a detailed order on 3/11/2025. Thereby asking the respondent authorities to bring on record their stand by filing the affidavit. Further to that, this court have also opined that the question as to whether there is a necessity of passing any interim order shall be considered on the next date. However, on the next date, time was sought for by the petitioner. And thereby this court fixed the matter on 15/12/2025. It is also seen that on 15/12/2025, when the matter was taken up, 1 week time was again sought for by the petitioner to file a reply. In pursuance thereto, a reply has been filed on 16/12/2025 by the petitioner. First, the issue involved in the instant proceedings is as to the authority of the Regional Transport Authority to not to permit the diesel buses in route number 23 and route number 36, wherein, in respect to which routes the members of the petitioner association, 73 plus 94 plus co-ed both of them. So numbers of members of the petitioner association are plying their buses. Mr. K.K. Monto, the learned senior counsel appearing on behalf of the petitioner, submitted. That such action which is sought to be taken by the respondent authorities is only permissible if the mandate of Section 99, if the mandate of Chapter 6 of the Motor Vehicles Act 1988 is adhered to. It is the submission of the learned senior counsel that the very decision which have been taken to oust the members, the so many members of the petitioner association is to accommodate the buses run by the Assam State Tourism Corporation, which is a state transport undertaking. He therefore submitted that without following the mandate, more particularly in respect to Section 99, of floating a scheme, asking for objections, and thereupon taking a decision, the respondent authorities have no authority or jurisdiction to do so. In addition to that, the learned senior counsel have also referred to Section 67 of the Motor Vehicles Act 1988, whereby the power has been reserved to the state government to control road transport, including the power to make schemes for transportation of goods and passengers and issue licenses under such schemes for the promotion of development and efficiency in transportation in respect to protection and enhancement of the environment. The learned senior counsel submits that this power, which is only reserved upon the state government, can only be implemented by way of a notification in the official gazette. And since SANS, such power being exercised, the Regional Transport Authority has no authority to do so. Per contra, Mr. D. Nath, the learned counsel appearing on behalf of the State Transport Authority, appearing on behalf of the state, submitted that the Chapter 6 of the Motor Vehicles Act 1988 would not be applicable, taking into account that it is the decision of the Regional Transport Authority to permit every person to run in route number to permit all the members of the petitioner, members of the petitioners who have existing permits in route number 23 and 36, subject to they converting their buses to CNG or electric vehicles. The learned senior government advocate had also submitted that as it is not purely a decision only to accommodate the state transport undertaking, that is ASTC, but it is open to all the members of the petitioner, but it's also open to all the members of the petitioner association if they convert to CNG/electric. The said decision, Chapter 6 of the Act of 1988 would not be applicable. Insofar as the submission pertaining to rules section 67 and the power of the state government to float a scheme in that regard. The learned senior counsel, the learned senior government advocate have referred to Section 72, bracket 2, bracket Roman 22, and submitted that the Regional Transport Authority may, after giving notice of not less than 1 month, vary the conditions of the permit, as well as attach to the permit further conditions. The learned senior government advocate further submits that this also includes the power to alter the specified area, the specified route or routes. The learned counsel senior government advocate therefore submitted that in the instant case, the Regional Transport Authority have done so in exercise of the powers under Section 72(2) Roman 22. And therefore, the question of interference does not arise. This court have given an anxious consideration to the respective submissions. And it is the opinion of this court that further deliberation would be required on this aspect as to the applicability of Chapter 6 of the Motor Vehicles Act 1988, as well as Section 67 of the Act of the said Act. More particularly taking into account that the respondent authorities have taken this decision, as would be seen from the minutes of the meeting dated 5/4. Where that meeting, page 141 or something?
Yes, 141. madam.
Page 141.
Of my affidavit.
Taken the decision. In the minutes of the meeting dated 24/12/2024, keeping in mind the suggestions of the managing director of the STC and recommendation of the DCP Traffic Guwahati. Under such circumstances, this court, therefore, is of the opinion that the instant writ petition requires an early resolution of the dispute. Accordingly, this court fixes the instant writ petition for final disposal on 8/1/2026 at 2 p.m. This court further this court also takes note of that amongst the 82, 94, or 73 plus members of the petitioner association, 35, na?
Para 13 of our affidavit.
36, 32 numbers are applicant, 32.
32 members of the petitioner association has already migrated to the alternative routes. Leaving behind total 2 per minus 32 per minus members. Full stop.
Already applied.
32 have applied, 4 have already.
Change their.
Total 36. 36 have already, 36 of the members of the petitioner association have already gone ahead with the impugned minutes of the meeting dated, leaving behind.
Indicate they were compelled to change.
Leaving behind so and so. This court further takes note of the submission of Mr. K.K. Mohanto, the learned senior counsel at this stage, who submits that these members who have migrated or applied for had done so under caution. Be that it may, comma, this court also takes note of that in some of the cases, in some of the cases, the members of the petitioner association's licenses permits are to have expired or in the verge of expiring, and some are in existence. Full stop. This court inquired with Mr. D. Nath, the learned senior government advocate, as well as Ms. M. D. Bora, appearing on behalf of the Transport Department, as to whether the respondent authorities would renew the license permits of the petitioner, of the members of the petitioners association in the other routes. They submitted upon instructions that the respondent authorities are not adverse to renewing, would be renewing the permits upon due application. Considering the above, this court therefore, till the next date, observes the following. Number one, the members of the petition association who have not applied or migrated till now is given the liberty to apply for fresh permits in the alternative suggested routes by the respondent authorities. Such application shall be without prejudice to the present proceedings. Number two, this court further observes and directs that the decisions so taken to convert the route number 23 and route number 36 into green routes is subject to the outcome of the writ petition, which this court shall consider on the next date. First. Number three, this court observes and directs the respondent authorities upon application being filed by the members of the petitioner associations to grant permits in the alternative, to issue permits in the alternative routes so suggested, subject to fulfilling the other requirements. In doing so, the respondent shall also duly consider that non-renewal of the permits would result in taking away the livelihood of the members of the petitioner association. List accordingly. On the issue notice in the other one, issue notice making it returnable on 8/1/2026 at 2 p.m. Miss,
It was already there, my lord. Which one what you be saying?
Another one.
in the second one, I have to issue notice now.
That order should go in here one. What you has not dictated. Should go in here.
Don't worry, I know how to draw it up.
But it is hands of the indicator.
Mr. So-and-so accepts notice on behalf of all the respondents. Who is accepting you? So-and-so accepts notice on behalf of all the respondents. Taking into account, extra copies of the writ petition be furnished by tomorrow. Date to DDO. Taking into account that the instant writ petition is correlated to WPC number 6117/2025, comma, wherein this court today have passed the detailed order the said order be read in as a part of the present order.
Item 48 fixed at 2 p.m. for motion.
What is there? You filed affidavit.
Probably there was no need to file an affidavit, Lordship. Probably there is no need to file an affidavit because there is no minutes. If I may just submit this, Lordship. Lordship had asked me to place on record if there is any minutes. But the communication that I have received from the authorities indicates that this is how they have done it.
How?
If your Lordship will see.
So we go as per the comparative statement. So we set aside.
They take the second ground also, the auditor's report.
No, whatever may be, but that's not the ground. We set aside that.
They say, therefore, hence the bid has been rejected. So this is also not very clear otherwise. I tried, Lordship, I asked them as to, but this is what they are giving me. So it seems like though the bid submitted by the petitioner does not have those documents, but it is not reflecting in their decision-making process.
No, you have this ground, you do one thing, you take a fresh technical approval.
I think that will
But
be
we have to set aside the work order.
private respondent.
He's not appearing, the none appears. Very well, good. Better now. Which state? He's not appeared.
Lordship,
Lahore.
may direct us for re-evaluation.
No, I can't. He's not appearing to his state. Heard Mr. Allen he icon main icon of petition. It is 6542/2025 7076. Are you to do that at order? In both the writ petitions, this court had passed certain orders on 12/12/2025. Thereby inquiring with Mr. A. Sharma, the learned standing counsel of APT's DCL, as to whether there were any minutes or any contemporaneous material which would otherwise show that the reasons for rejection of the technical bid of the petitioner was on the ground of non-compliance to clause 4.3 Roman 6 and 4.3 Roman 13 of the bid document. In pursuance thereto, Mr. A. Sharma, the learned standing counsel, have placed before this court a communication issued by the managing director of the APT DCL dated 15th of December 2025, wherein it is mentioned that there are no contemporaneous records and or minutes of the meeting recorded, and it was solely based upon the comparative statement of the technical bid. In the order which was passed on 12/12/2025, this court categorically held that the reason which appears in the comparative statement under no circumstances can be read into as reasons in terms with clause 4.3 Roman 6 and 4.3 Roman 13 of the bidding document. Under such the nature, the consequence of the above, it therefore appears that the rejection of the petitioner's technical bid was on conditions which was foreign, having no nexus to the bidding document. Consequently, it is the opinion of this court that this is a fit case where an case of passing an interim direction has been made out accordingly. This court therefore stays the
Minus 9.
work order dated 14/10/2025. Issued to the respondent number 4 in the present proceedings till the next date. List this matter again on 9/1/2026.
I appear for respondent 4 months.
Very well. Mr. D. Gogoi appears for us.
Lordship could have passed the final orders now since he's here.
No, he was not there. Why should I?
Flexing 415.
Huh?
Because Lordship, otherwise this is
Go to court 15, go to court number 1 now. Take a file and appeal.
This is otherwise a building of hostel for students. Construction of a hostel. The upgradation is going on. Now because of the stay, the hostel cannot be used and the students will be now in a difficult position. Polytechnic College hostel.
Who are you?
Technical education.
Our college is.
The college belongs to them. We had floated the tender for construction of that hostel upgradation. Now he is doing this work. And difficulty will be ultimately the students will suffer.
Then we set aside the work order. Ask them to re-evaluate from the technical point of view. And thereupon take a decision.
At least things will keep on moving then, Your Lordship. Otherwise staying.
That
will
is
be
the
like-
only way.
Well, I understand. But I have done,
That is immaterial. Tomorrow, if I set aside and ask them to re-evaluate his tender, and then the managing director doesn't look and find your case face nice, they may again accept his. Then I can't help you.
no, my lord, since
But-
I've used cement now, which is become concrete, it's a building, my lords. I have invested money and that has, because they'll again suffer. I'll also suffer, they'll also suffer because much work I have done.
Who is going to suffer?
That bill part, my lords, that whatever work I have done, if it is set aside also, I have no quarrel to that. But my part, that which investment I have done,
So file civil suit.
ultimately.
They have wrongly given it. Because of their fault it has happened. File a civil suit then, if they don't give it. Or wait for a stay, we'll consider properly after a long vacation.
Then that we did recourse. Lordship is, if Lordship is proposing that recourse, my lords, that we can, that I agree. If Lordship will look into my aspect also. After if it's taken after vacation, then I agree to it.
But I'll stay it.
Lordship, then I'll also stay everything.
Staying again will be against the public interest because ultimately that building will not be able to be used and the students cannot occupy the building. So the only fact is that yes, it is a fact.
No, but
He has-
problem arises because of you. You have caused the problem. Why your people, the 3 persons, one is the managing director, one is the OSD, one is the chief engineer, they don't know how to read the English or write. Isn't it the saddest part? They don't. What is the language used? Even trying hard by Mr. A. Sharma for a long time also, he is not being able to persuade me. Even Mr. D. Gogoi cannot also be persuaded in this regard that would connote it's a violation of that he has not followed 4.3 Roman 6 and 4.3 Roman 13. And they don't minute also. Can anything, I even gave him one chance that if there is any contemporaneous material, bring it. They said we have not done anything. We have given what is there in the consolidated chart. What to do? Tell me. Give me a good reason. So the only thing is that is one course where I'll set aside, ask him to look into the technical bid because that is the more reason. And he has to therefore submit that he wants to do so. Otherwise, the entire tender process goes.
That I want to do so because I want the things to keep on moving. Staying will They stalemate everything, Lordship. Stalemate everything. The only thing is that he has done certain work. That is true. In fact, I in my affidavit have also annexed those photographs indicating that those construction civil works have been done. We can go for a Lordship verification as to what amount of work he has done. And in fact, that probably can be given to him, that amount.
No, no, no.
I do not know. I'm just placing it for
That
Lordship consideration.
I
because
cannot deal that, no?
it's a fact that he has done work and photographs I have annexed to that effect. So if some percentage of work has been done to that milestone, whatever bill amount is there, that can be, I think, be paid to him. So I admit it's a fault on the part of the corporation having not assessed his tender paper properly, petition assessed, but there is no fault on the part of the private respondent as such otherwise, because he is otherwise compliant. His bid is otherwise compliant. Somewhere to balance, Lordship. And this corporation never had the experience of floating tenders earlier. This is only for the first time. This year, they have entered into these roles.
What is that
Lordship.
corporation?
Assam Plain Tribes Development Corporation. We were basically a corporation meant for the welfare of the plain tribes.
Why didn't they take the help of Mr. Ardhor?
Next time we'll have to advise them. We'll have to advise
the
them.
help of Mr. Ardhor. He is the person who will help you out. It is a bifurcated corporation.
Yes.
Yes. Hmm.
There's lack of knowledge on their part also. They do not know how to do all this tender evaluation process properly, Lordship.
Mr. If I don't get any handle, it becomes very difficult. I have the opinion, I want to do it, but I don't have the handle. You have, if you don't give me any handle, how do I pass an order? Tell me. I want to, okay. I know one thing, that if you reevaluate, you are going to cancel him.
Because auditor.
No, you are going to cancel him.
Yes.
But in the interim, can I ask you to reevaluate? That is the problem.
With the work order
Without
being-
touching the work order, and if can I ask you to reevaluate, that I cannot.
No.
Problem in revise is there.
No, Lordship may therefore very
We
well
do one
set aside
thing.
the work
No,
order.
one thing I can do additionally, we stay his and ask you to go for a fresh reevaluation.
But then the work order remains.
We stayed his.
Stay, yes.
Order is wrong.
Yes.
I also know that my order is wrong.
Yes.
He can file an appeal. And having the good judges out there in the division bench, they may help him up more. But this can be done because I also know the future is that if I allow you, you are going to reject him.
Taking all the good grounds we have now.
You are going to reject him. But can I do this now?
I issue is like the order was work order issued in the month of November. No, in the month
Work
of
order issued on
October.
14/10/2010.
14/10. Had he approached that with swiftness, man, I could have not proceeded.
His specific submission as
Yes,
of
yes,
now
but
is,
I didn't
you've seen that order.
he didn't
That-
get it.
no, as of now,
Not
it's
up to
not
the
there in
No,
the
after that, I
portal.
understand, man. That is why I am not.
Is it there in the portal?
Right.
No.
No.
Therefore, I'm not arguing on that aspects also, Lordship.
Then I have no.
Therefore, I'm not arguing or disputing on the aspect of
So
delay or
how
anything
can
else.
we go on the question of delay?
That is not an issue. That is not an issue now. But what Lordship is saying, probably that is the most apt proposition as to.
That would not be proper now.
It is not. That's why I was saying, because the order is there on record. Lordship is staying it, but then Lordship is. So
We
if
have
you-
to take the risk. Otherwise, we have to set aside. We have to, there's no
At
way
least-
out
At
but to
least they
set
can
aside.
evaluate because whatever work I have done is admitted. That part they can at least consider, verify.
Then it will go for a fresh tender. Are you not understanding the problem?
Right.
The moment it is given to, some portion is given to out, means there will be a truncated the contract agreement. That
Yes.
means it will be issued on a fresh NIT. If a fresh NIT is being issued, he gets time to correct. Are you thinking in the form of your client or him? It is in his favor what the submission you are making.
So let him wait for some time then.
Well,
I think that is
I'll
better.
wait.
Let him wait for some time
Okay.
for his bills to be cleared.
This is the only way out. Because otherwise that order is wrong. If I keep it in the interim and allow them to do it, means I am allowing them to post rationalize, which is not permissible.
Yes, it will not be correct in fact.
Problem there. We therefore, in many cases, we set aside and then the authorities correct it.
So Lordship will set aside the technical evaluation decision as well as the consequent work order and allow us to do it
That is
afresh.
the what he has problem, he wants to think
Because
over during the New Year's.
he is anxious about the work that he has done and put
No,
his
they can't
interest.
help it.
That is,
You have a claim,
My lords.
you can make a claim if they don't give it. Because, but by that, the tender is there.
My lords.
The proceedings is again reprocessed. It's a reprocess. I'm just set aside the technical evaluation of him, rejection, and directing them to freshly reevaluate.
Yes, Lordship. I think that will be better.
What?
Yes, sir.
I'm
Better.
in the wisdom of him and him by itself.
You take the wisdom of, you take the wisdom of your client on 9.
9.
Nine. Huh? 9. Okay, we got it. But this is the order which you are going to get at the end of the day, if I am sitting.
Is Lordship sitting on 9th?
I don't know.
Then
So therefore
difficulty
I'm
is there.
saying, if I am sitting, this is the only order you are going to get. But you never know. And 9th, we are going to have our foundation day on 11th. So maybe it may not reach also.
My submission is Lordship will pass a final orders. I think his rights will be protected ultimately. I feel so. I cannot take it, but I feel so. That's what I'm saying. I feel so.
Go outside and think about.
My lords.
We'll have, okay, let us have it on 19th.
This 19th.
19th of the day.
Yes, Lordship.
Think about 2 nights.
Right.
We'll see then.
19th, Lordship.
Mr. Ringe, your case is going to go later on, but you need to have a satisfaction of coming to the court also.
Oblige you, Lordship.
19th, huh? 2 p.m. Stay till then. Stay at the Didis.
Stays there.
Stay has to be given. Huh? Let him have some satisfaction
Yes,
before the
yes.
vacation. Yes, what is this?
Time to file reply to them.
Oh, your case. That case, na?
They filed the reply on yesterday.
You want to file a reply. Very well, very well. When? May? No, January, no time. February? Okay. Mr. B. Bolwa, appearing on behalf of the petitioner, submits that the respondent number 3 has filed an affidavit in opposition on 16/12/2025, and the petitioner would like to file a reply. Full stop. Taking into account the above, list this matter again on 4th of February 2026. In the meantime, the petitioner shall file the reply on or before 2nd of February.
In this matter, we have been engaged yesterday, we are the private respondent.
You want to file a reply?
My lord will file an affidavit in
Okay, Mr. So-and-so, who represents the respond number?
6 months.
6, submits that he would file his reply on or before 9th of January 2026. To stop taking into account the above, the respondent number 6 shall file the affidavit in opposition on or before 9th of January 2026. Petitioner given liberty to file reply thereagainst also on or before 2nd of February.
Highly obliged.
Made to the lordship. My lord, item 52, 53, 54, and 55 are similar to item number 9, which my lord has just. So my, this subject, my lord, similar orders may also be passed review.
Mr. Burago, I have become more clever during the lunchtime. I should add one more line out there that you cannot permit to run. You have not registered.
Even I was thinking at the point, your lordship, this writ petitions which they have filed, they have said, we said that you are not registered, so we'll not renew it. Till that they are not registered. So what's the cause of action arise here, your lordship? What's the reason for this challenge?
This is not transfer, it's a change.
They are going for conversion, but still they are on. Still their license is on license. Their license has been converted to off. Still they have not registered themselves.
Same order will do.
Same order.
That
will-
order, I made it only clear that I'm not passing anything. However, pending disposal, next date, they can get registered.
Yes, my lord.
And you can only consider your application, his application for conversion, if he is registered.
Very well. Yeah, that.
That is the order which I
Yes,
passed. If they don't do it here, and I hope by then, the dimming lights of the finance and the taxation department becomes more illuminated, so that you can take some action and ask them to stop working out there, stop these wine shops. See, section 21 of the VAT Act, it categorically says no person can carry out any business unless he is registered if he has to pay tax. Stop that.
Yes, exactly.
Stop these people. Same order.
The location of the shop would be different because otherwise.
Location too. You give the locations.
I'll give the location.
Obliged,
I
Lord.
can 52 to 55 now. I'm obliged. I'll give.
Mr. R.R. Gogoi, are those petitioners nothing to do with those withdrawal petitions? Na? Check out those dates. There were 15 petitioners of Mr. N.J. Khatunian.
Yes. In that he has even they have put this challenge this renewal. They
have challenged the same where they
Same.
withdrew without liberty.
without liberty.
Hey, find it out. Have your client filed earlier with petition?
No, they have not filed. This is different. This is completely different. I've checked it out.
Therefore, I'm saying, because those are 15. Here we have single.
My lord, I have checked that, but they haven't filed the earlier case. These are all.
Fresh.
fresh cases.
Obliged, Lord.
I'm obliged.
Yes.
This by the judgment, if 1/4 is delivered at page 37.
Why, which judgment?
Judgment passed by the additional district commissioner.
Huh?
Passed by the additional district commissioner
Where?
of Tinchukla. In revenue appeal number 07 of 2020.
Page.
37. This order judgment was passed erroneously, arbitrarily and illegally also.
Let us see. Revenue appeal passed by so and so. Who has passed this?
The additional district commissioner, Tinchukla. That's for number 3, I have made a party by name.
Has the board of revenue stopped working?
Yes.
No, I'm
no,
asking you. No, Mr. Dhar. Has the board of revenue stopped working?
No.
Good.
They are in full place, Lordship. Now judicial member was also appointed, Lordship.
See?
And technical member, judicial member, all are there, Lordship.
Case 43. I have made a.
I would have understood when you have come against the circle officer's order. I would have said that, okay, then he has not. But once you have taken the steps to go to a appellate tribunal, you are not going to the second appellate tribunal and directly coming. They are writing letters to us.
Page 43.
They are writing letters to us, to the Chief Justice. Look here. Last year, out of earlier in 1994, 97 or year, there were around 8,000 cases. Last year, the filing is only one.
3 months back, Lordship, we have appointed the technical member and judicial member. Lordship.
See?
What is?
They are paying fee. We do it. What is this? What is this salary?
Salary more than Lordship, 1,50,000.
Okay. You pay deposit that.
If your lordship comes to page 43.
No.
because I have
I am not
reviewed
going to entertain this.
Before the deputy commissioner to.
What is this case? What is that order?
Transfer that case from that soap to another court lordship.
Okay, let me see if I can dismiss it. But Mr. Dhar, I will look into it. If I will dismiss it, no board of revenue later withdraw. You take that risk. Don't take that risk. You want to take, I'll take it up. Don't worry. But if I dismiss, no liberty, withdraw. Take it. Let us do it. What? Withdraw? Heard Mr. Ardhor, the learned counsel appearing on behalf of the petitioner. Mr. Mr. Arbor Pujari, the learned standing counsel of the Revenue and Disaster Management of Government of Assam, as well as Mr. K. Gogoi, who appears on behalf of the district administration. The petitioner herein have challenged the order dated 1/4/2025, passed in Revenue Appeal number 7/2024 by the Additional District Commissioner Revenue Tinsukia, whereby the appeal against the petitioner was allowed, thereby setting aside the impugned order dated 7/2/2024, passed in Miss Case number 18/2024 by the Circle Officer Margareta, Revenue Circle, Margareta. Full The learned counsel appearing on behalf of the petitioner had submitted that the petitioner that the impugned order dated 1/4/2025 is absolutely illegal and requires interference by this court. Per contra, Mr. Arbor Pujari, the learned standing counsel of the Revenue and Disaster Management Department, as well as Mr. K. Gogoi, the learned counsel appearing on behalf of the district administration, had submitted that the petitioner has an alternative and efficacious remedy available under Regulation 147 of the Assam Land and Revenue Regulation 1886. And therefore, the petitioner, this court may not entertain the instant writ petition. Mr. Arthur, the learned counsel appearing on behalf of the petitioner, on the other hand, submitted that the period of limitation for filing an appeal thereagainst before the learned Board of Revenue is 3 months. And as the impugned order is dated 1/4/2025, the petitioner would not be able to file, taking into account that it is already barred by limitation. It is the opinion of this court that if the respondents herein raise the issue pertaining to entertainability of the instant writ petition on the ground that there is an alternative and efficacious remedy, this court cannot relegate the petitioner to the statutory appellate forum unless and until an opportunity is granted to the petitioner to file the appeal. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. This court is not entertaining the instant writ petition in view of an alternative and efficacious remedy available in terms with Section 147 of the Assam Land and Revenue Regulation 1886. Taking into account, number 2, taking into account that this court have relegated the petitioner to the learned Assam Board of Revenue, this court observes that if an appeal is preferred by the petitioner within a period of 30 days from today, the learned Assam Board of Revenue shall entertain the appeal without insisting on the question of limitation. See? It did not withdrawals. I gave you everything.
It's sought to approve this matter so that this could be taken up in the hopes that it would be taken up before lunch, because my senior Mr. Chaudhary had to travel outside the second half. So he has left for lunch in the house. I request that it be taken on.
It's okay. Don't worry. I'll take care of yours. I know what is Mr. Chaudhary's arguments. You are going to refer to that judgment, that NHIDCL's judgment, isn't it? That I've heard it on this matter. I've heard it. I know it by heart. The only question is that NHIDCL judgment would be only applicable. It says that once you only appear, participate, then only you can say about the illegalities committed.
Indeed.
Now you have given a particular undertaking. You have given an undertaking, but that undertaking is what you call not getting the word, a qualified undertaking. It's a qualified undertaking saying that this is this. You are saying that the clause is bad. The clause does not have proper if it is a case of a force measure, then these things are not being duly considered. But otherwise, you say that the bridge which has broken off is due to a force measure, and the Patna High Court have permitted you to continue with the construction, so there's nothing out there. But the fact remains that the bridge has been broken off. That is one of the grounds for which they have rejected. The second ground is on the question of the financial there, which doesn't merit.
My lord,
So this is your submission.
my lord, done.
So let's hear them, because they have come from Delhi.
As my lords may think fit, my lords. We have also come from Delhi for this purpose only. We had come with the hope, even on the last date of hearing.
Mr. Counsel, I'm going to give you the chance.
As my
Don't
lord.
worry.
As my lord.
Let us hear him. They've come from Delhi. Are you?
This case has to be heard, but there are two judgments which cover the entire case. The judgment of your lordship, Asian Energy, that judgment has been discussed by law. What is his locus? What is his locus? One is that in the first petition, he filed the first petition challenging the terms and conditions of the alliance. Terms and conditions clause 2.2.2.4.
2.2. And I have read two judgments of this court. Asian Energy, everything, all judgments has been covered. All judgments. I have marked that. Two judgments. And secondly, my lord, his case is that his undertaking is not a clear, it's not a clear undertaking which he has given.
No,
His undertaking.
No doubt. He also admits that his undertaking is a qualified undertaking.
Yes.
It is for the railways. They say that they, under no circumstances, any bridge being broken, we don't want anybody. That is their step. Now the question out here before the court is, can this court impose upon the railways? No, you have to accept it. Or can this court say that this particular clause is bad? That is why they have put the challenge.
Right.
Because they say that the construing of this particular clause in this manner, which they should not have rendered it arbitrary.
But my lord, rendered in arbitrary. But before coming to court, they could have challenged this clause. Why they have not come up before it? Before they should have come up and challenged their terms and conditions, because that terms and condition could not have been challenged by them. That terms and condition 2.2.42 could not have been challenged by them, meaning thereby they doesn't qualify. They doesn't qualify that terms and condition. What is their locus? Now, once they participated and they are questioning about the terms and condition 2.2.2.4, what is their locus to come up before the court? That's exactly what your lordship judgment decided Asian Energy. And my lord, I have gone
The
to...
appeal is pending.
I'm sorry.
Appeal is pending.
But that appeal, my lord, that appeal, what that appeal? Well, ultimately, your lordship has to decide that writ petition. That is the last writ petition. What remains in this appeal, I don't understand, my lord. They may file an appeal. What remains in the appeal, I will decide.
Energy appeal is pending.
Where? No, no appeal. That's also clear. One of the paragraph in Asian Energy that said you become an unsuccessful candidate and you are questioning about the LOI of the other side, and the court will not sit as an appellate body to look into it unless you can show that particular terms and conditions.
This has also been said in Ronak.
Yes.
It's not I who have said it.
No, your
Ronak
lordship
has also stated that aspect in, I think, around paragraph 30, 31, I suppose
Yes.
they have stated that. But the fact is, whether he is whether his unsuccessfulness or the fact that he has been rendered unsuccessful is also a question before this court. If this court holds that that he's being rendered technically not competent is right, obviously he cannot challenge the LOI. So therefore, again, the crux comes back to the question as to whether financial condition which
No,
they have taken
financial
is wrong.
condition.
The first one, is it right? Can this court therefore look into the terms and conditions out there to the effect that we can impose upon them? We can't, the court
Yes, right.
under no circumstances can impose upon the authority concerned that you have to have this clause in this manner. The only thing this court can do is an exercise of a jurisdiction of certiorari, whereby this court may say that this is wrong, this is right, whatever it may be, and say that this is wrong because of the fact that it violates the mandate of Article 14, being it arbitrary, as the particular clause does not have the the manner in which you can distinguish the thing pertaining, if a breach has fallen not for his fault, if it is a breach fallen due to a bomb blast, how can he be put at fault? So these aspects having not been there, can it be said to be right or wrong? So that is the permissible, I mean, it is not that he has, if you see the NHIDC's judgment, which he will refer to, I think, later on, it is something like that judgment of the Supreme Court in the case of selection. Normally you follow that Madan Lal versus state of J&K. But if you have the judgment of Abhishruti Chakraborty, if I'm not wrong, in that judgment, the Supreme Court says that if in certain cases where without the participation in the selection process, you cannot know that what is the fault out there or regarding violation of Article 14. So that is the scope in which NHIDCL has been developed. So therefore, the question is, can it be said to be proper? Yes, they may very well inquire and find out to that effect. But can you just outrightly reject on that terms? Or if you outrightly reject, can you say this particular term to be reasonable? That's the
That's
scope.
my lord, there, if your lordship sees 2.2.214, it's a collapse so far as design and structural is concerned, my lord. Design and structure. They knew about the terms and conditions very well. My question and answer will be they knew it very well. So if they knew it very well, the terms and condition, why there is not a clear undertaking which is given by them? Why not a clear undertaking was not given by them? That is the ground where the railway have rejected the terms on the basis of that, because they didn't have the clear.
There should not be a history of collapse of superstructure.
Yes.
Oblique substructure of any span of the bridge, flyover, viaduct, metro link line during construction service in the last 3 years, ending so and so. Previous to the one in which tender is invited. Undertaking in this regard shall be submitted along with the bid.
There is a clarification in the corrigendum. If your lordship looks
Is the
into.
corrigendum?
Yes, there is a corrigendum.
Which one? Which petition?
Yes.
6625.
Yes, corrigendum, you get the corrigendum.
147.
140
Of the first writ petition.
First,
See,
writ
don't worry. Am I not putting the question which you are going to put? Take your seat.
Yes.
148 is the.
148. 148. Clarification 148 of the first writ petition.
Serial number 22.
Serial number 22, mine. Lordship got it?
Huh?
22.
148.
140. First writ petition.
The first one.
First writ petition.
Where you are not a party.
Yes. There is a statement. Well, that day I said, I have gone through it. One statement has been made against us also. In that. Yes.
Yes, where?
22. Also got it, my lord. And please see the right-hand side clarification. Clarification has been incorporated in revised RFP. Collapse of superstructure, substructure pertain to design failure or quality-related failure or permanent structure would be considered in this clause only.
So therefore, you say that this particular clarification makes it very clear that if it is only in respect to this, nothing to do with bomb blast, pertain to design failure or quality related failure of the permanent structure.
Yes, correct.
Which has nothing to do, even for force measure also would not
Yes,
apply.
not apply. Yes.
Chalo. Okay, when can we hear you?
My lord, just one actual clarification.
No. You give yours. When can I hear your senior?
My lord, anytime after reopening, my lord, earliest possible time.
It starts from 5th of January 2026 to 23rd of December 2026. When do you want?
First week, second week of January, my lord.
Second week of January. Okay.
Subject to my learned seniors convenience.
Can we have it on 20?
My lord, may have an earlier date possible.
The reason is why I'm saying is this. Courts are reopening on 5th, 6th. Okay, we can try on 6th.
20.
Possible?
20. 20, my lord. 20, your lordship is 20.
6th.
Oh,
1.
yes, fine, no problem. It's okay. There is no problem. I'm, my lord, I'm afraid of looking into the record.
No, we don't require so much of record. We directly get that record only. You see, the record pertaining to you see, initially you had an RFP. Then, pursuant to that, various bidders came over.
No, it's okay for me.
And they submitted various requests. And on the basis of which this corrigendum was issued and a revised RPF have been issued. That is one. No, that is one. And second is your decision why you have rejected that minutes. Why do you need all the records? Unless you want to instill fear upon this court. That only that. But because you see their allegations. The allegation is that look here, they made it 3 years only to accommodate L&T and another one. Whereas not. Whereas you say that we have put 3 years, and if you in any manner we are going to touch it, then in that regard it will take away a lot of other people's like K. All these people are there. So this is your submission. So therefore, that corrigendum, how this corrigendum came into being, that record is required. Secondly, they say that you have not applied your mind in that regard, and therefore your minutes will speak on its own. So these are the two files. And the minutes. No, the minutes of the technical committee. That's all. Okay. Chalo. Okay. Having heard the learned counsels appearing on, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner in both the writ petitions, Mr. K. Gogoi, the learned CGC, who appears on behalf of the respondent authorities in both the writ petition, and Mr. D. Das, learned senior counsel, assisted by so-and-so, who represents the respondent number
3, my lord.
3 in WPC number 6625/2025. Gustav. This court have fairly heard learned counsels appearing on behalf of the parties. And it is of the opinion of this court, no, full stop, full stop. The submission on behalf of the learned counsel appearing on behalf of the petitioner is that some more time is required, taking into account the submissions so made by the learned senior counsel appearing on behalf of the respondent number 3 in WPC number 6625/2025. Taking into account the above list taking into this court also duly takes note of that there is no interim order has been passed, and as such there is a requirement of an early disposal, more particularly in view of the observations so made by this court in the order dated 21/11/2025. Accordingly, this court fixes this matter on 6/1/2026 at 2 p.m. for final disposal. Full stop. So during the course of the hearing, Mr. K. Gogoi, the learned CGC, have shown before this court that there is a rack pile of records, and would it be necessary for him to retain everything? First of, it is the opinion, taking into account the allegations which have been made in the instant with petition, it is the opinion of this court that the files relating to the issuance of the corrigendum dated. What is the date corrigendum? Issuance of the corrigendum, which is Annexure 6 to WPC number 5051/2025, as well as the files pertaining to the respective bids of the petitioner as well as the respondent number 3 and the technical minutes be placed before this court. The rest of the records be returned to the authorities concerned.
Corrigendum is 2307/2025.
2307. Anything more?
Sir, Manoj, there was also the direction of filing a reply to 5051 to respondent number.
No, if so advised.
If they don't want to file reply, my lord, we thought that no reply is required because there was a question of prejudice that my lord had raised.
In the meantime, a final opportunity is given to the respondents, respondent number 3, to file any reply if so advised on or before 5th of January 2026 by serving advance copy upon the counsel for the petitioner on or before on 31st of December 2025.
Yes, reply of this.
We have filed a joint affidavit. We have filed a joint affidavit. Joint affidavit has been filed.
Yesterday also one matter
Lordship.
got solved. It was a way, one thing very good about that matter is, I don't know about this. It's a sense of normally a labor court or a workman matter needs to be taken up as urgently as possible. In fact, the Supreme Court in one of the Constitution bench judgment also observed that even a person should not be given a right to file adduce evidence by the management if he does not take the plea. And the reason is also being given out there that it will otherwise take away the morale or break the morale of the workman. This is the basic idea. But it is really disheartening to take note of that in this our court, what is happening is first day when the labor court awards are being challenged, a rule has been issued, and resultingly 10 years, 12 years, 14 years, the matters have been pending. That was a matter of 2005. The issue involved is that there was an illegal strike. You see, there's such a sad part. It was an illegal strike which went to the labor court, and the labor court rejected it. But the labor court should have passed an order to the effect that, look here, matter should have been finished of the okay, that is there, but then also now the continuance of the strike was not necessary. But labor court did not, which resulted in filing a writ petition in 2000 4 or 5. I took up the matter in 2025. When it came up before me, I saw that now I can't do anything. This is the Billworth building. From 1998, it is being closed. Now to question, I can't declare that the declaration that the strike is illegal is right. I can't touch it. But the continuation of a strike to be illegal, I can't touch it because I'm the. At the end of the day, I therefore requested both the councils and they have now come up and they have already agreed. And yesterday I recorded and concluded that matter. So at least those workmen could get something.
Lordship, that
Yes,
is-
otherwise means, yeah. Anyways, IA file, na?
Joint affidavit.
Is it the IA? No.
IA, your lordship, before your,
IA, no.
IA will not be necessary.
Okay, additional affidavit file. Okay. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. S. Bottakur, who appears on behalf of the respondent. Number 2. Mr. S. Bokel, appears on behalf of the respondent number 1. The petitioner herein have assailed the order dated, award dated 23/10/2024, passed by the Learned Industrial Tribunal, Assam, in reference case number 07/2022, whereby directions were issued upon the petitioner to continue the services of the workmen with effect from 2/1/2021 by giving equal pay and allowances as admissible under the Majita Wages Board judgment. This court took up the matter for hearing on 2/12/2025. And while during the course of the hearing, this court inquired as to whether there is any possibility of an amicable resolution of the dispute between the petitioner and the respondent number 2. In consequence to that, the learned counsels appearing on behalf of the petitioner had submitted on 4/12/2025 that some sort of negotiated settlement have been arrived at between the parties and they would like to file a joint affidavit. In pursuance thereto, a joint affidavit was filed by the petitioner and the respondent number 2 on 17/12/2025. In the said joint affidavit, the understanding so arrived at by and between the petitioner and the respondent number 2 have been duly noted in paragraph number 1, in paragraph number 5.
5 and 6.
5 and 6. First of, it is also seen that at paragraph number 7, details have been given as regards the bank accounts of the 8 members of the respondent number 2 association. It's an association
Lord,
or union?
union, Lord, not a.
Respondent number 2 union. Full stop. Taking into account the above, this court finds it relevant to reproduce paragraph number 4, 5, and 6 of the said joint affidavit. Full stop. Next. The above terms, the above understanding between the petitioner and the respondent number 2 is a compromise arrived at by and between the petitioner and the respondent number 2. The said compromise, in the opinion of this court, is out of the free will of the petitioner and of the parties here too, and without any caution. The contents of paragraph number 4, 5, and 6 as quoted above shall be therefore binding upon both the petitioner and the members of the respondent number 2. First, taking into account the above, the instant writ petition therefore stands disposed of in terms with the agreement, in terms with the compromise reached as recorded at paragraph number 4, 5, and 6 of the joint affidavit. First, the joint affidavit next shall the joint affidavit shall be a part of the instant order. Next, both the petitioner as well as the respondent number 2 shall file affidavit of compliance before this court on or before 8th of May 2026. The instant proceedings accordingly stands to stop.
Deeply observed.
I closed, huh?
Affidavit has been filed, your lordship.
What is your stand? Is entitled?
Lordship, he is entitled, but Dal Shakti may be made party, your lordship.
Oh,
We have,
it is seen that this court have duly perused the affidavit filed by the Assistant Chief Engineer, Water Resource Department, wherein it is duly mentioned that the remaining outstanding liability of the petitioner is rupees 16,94,237. However, the said amount is partly sponsored by the Ministry of Jal Shakti, and without the said said department of the government of India being made a party, the instant proceedings cannot be, an effective order cannot be passed in the instant proceedings. Taking into account the above, list this matter again on 11th of May 2026. In the meantime, petitioner given the liberty to file an application for impleadment of the Ministry of Jal Shakti as a party to the instant proceedings. Failing to do so, it shall be presumed that the
Outline.
Prahlad Roy. Oh, Lanka. What is Lanka doing?
Well, we have filed the affidavit, but I have the instruction, well, that some consistency is going on. They are taking some decision, Manoj. Possibly they will allot them. Some time may be given, Manoj. Let it be taken after 2 weeks. In that meantime, they will take the decision, Manoj.
Taken after?
2 weeks, Manoj.
Heard Mr. L.N. Dihian, the learned counsel appearing on behalf of the petitioner. Mr. D. Nath appears on behalf of the Lanka Municipal Board. Mr. D. Nath submits that he has been given an understanding that the petitioner's hearing can be accommodated. And as such, this is discussed amongst the concerned authority in the Lanka Municipal Board. He therefore submits that the matter be adjourned for 2 weeks so that he can update the aspect.
Lordship,
Taking into account the above, list this matter on 6th of February 2026.
Lordship may indicate one thing, Lord. In the first floor and second floor. Ground floor is already filled up. In the first floor or in the second floor, they will be
In the first floor or the second floor of the building in which?
building.
Only 2 already allotted.
Yes, yes. Yes, yes.
But remaining are still.
Oh, that one.
That,
50 and 50 were adjacent.
yes, yes. In that market.
Ke-
In the
ke
first
wasn't
floor, and
that?
second floor, they may be accommodated. That first floor and second floor, Lordship may indicate. Not in the ground floor. Petitioners are harping for Lordship.
Ground floor is gone.
Yeah.
So first floor, no, if there is space, in the first floor or the second floor?
Or the second
Line to likhi dibo. It submits that the petitioner the authorities of the Lanka Municipal Board are discussing as to how to accommodate the petitioner in the first floor or the second floor of the building in question. He therefore submits that 2 weeks' time may be granted for an update.
Lordship.
List this matter on 6th of February 2026. What interim is there? Huh? Okay. Interim. Till the next date, out of the remaining 9 number of shops may be kept vacant.
13/3/23, Lordship has passed an order to
Stop.
keep 9 shops. But ground floor is already filled up a lot. Ultimately, in the first floor or second floor, they will be considered.
The interim order shall continue till the next date. However, the interim order so passed shall not come in the way of granting allotment to the petitioners if so advised.
No, Lord. Lordship.
Better one, na? Now?
Lordship.
Yes, Mr. J. Sharma. You and the forest department.
Lord,
always
instructions
in
are
touch.
there. We'll file an affidavit, my lords.
You file.
No, we'll file. It came late, my lords. Otherwise, my lord, he is selling a certificate of recovery certificate under the BPRD Act.
Interim order is there, na?
Hmm.
Was it vacated?
No, no, my lords.
Interim order was not there. Interim order no longer exists since 19/7/2023. Okay. You are not going to file affidavit?
We'll file, my lord. I have the instructions.
Mr. D. Gogoi, the learned counsel appearing on behalf of the forest department submits that he has the instructions have been duly provided and affidavit that the forest department would be filing the affidavit within
2 weeks we can file.
within 2 weeks. Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner on the other hand submits that initially when the writ petition was moved, this court, taking into account the case, had passed an order on 24/5/2023, passed an interim order on 24/5/2023. He further submits that the situations have not changed thereafter. Rather, the respondents have been taking time. However, the interim order though was extended, but since 19/7/2023, there was no extension. He therefore submits that the interim order so passed on 24/5/2023 be extended till the next date. Considering the above, lists this matter on 12th of February 2025. The interim order passed on 24/5/2023 stands extended till the next date. The forest department is directed to bring on record their stand by filing the affidavits on or before 30/1/2026. Liberty given to the petitioner to file reply on or before 9th of February 2026. On the next date, an attempt shall be made to dispose of the writ petition.
All right.
Regarding non-payment of contractual bills, last occasion they have asked for time to file affidavit.
It's a covered case, my lord. Just some days ago.
Covered means what covered?
Just some days ago, your lordship had passed an order There is a common inquiry report with regard to the same claim, my lord. That inquiry report.
Challan and all, we have
Same observation by the department. my lord.
How can it be covered when you have not filed affidavit here?
We will file it, my lord. In 2 weeks, we will file.
This court, Mr. Ibotakur, appearing on behalf of the PHE department, submits that the issue involved in the instant case is covered by the judgment of this court dated 26/11/2025 in WPC number 2689/2023. This court have duly perused the order dated 26/11/2025, the judgment dated 26/11/2025, wherein it is seen that the respondents have duly filed an affidavit in opposition, and taking into account the same, this court have disposed of the writ petition. However, in the instant case, there is no affidavit in opposition. Under such circumstances, since any affidavit in opposition being filed, it cannot be taken into it cannot be said that the order passed by judgment and order passed by this court on 26/11/2025 in WPC number 2689/2023 can be a similar matter. Mr. Ibotako, appearing on behalf of the petitioner, respondent PHA submits that an affidavit will be filed within 2 weeks. Lists this matter on 13th February 2026. In the meantime, affidavit in opposition be filed on or before 2nd of February 2026. Mr. Botako, you take this. Same, na? Same order. Will you file? If you don't file, then otherwise the other case goes. The four-pronged. Yes, Mr. Mukherjee.
The picture is that her husband used to run a shop with a trade license. Husband expired and the lady was continuing with the shop. He paid for transfer of the trade license in her name. Pursuant to the order which was passed on 3/1/2024 in the city.
You applied fresh application. Then what happened? You got it? Why?
They have renewed the trade license in my husband's name recently. Yesterday I took instruction. 2025-26 trade license is renewed in the name of my late husband. That
And
is-
your husband has how many wives? Only wife? You? Well, you know,
No, the problem is that, my lord, we have asked, suggested her you obtain a NOC from the landlord, because there is a condition in our provision that whenever we have to give a license, so we have to obtain a no objection certificate for our tenancy agreement from the landlord. Now, my lord, the building is 90% almost demolished because of the report of the executive engineer, PWD, that it is a dilapidated condition, maybe it caused harm to the.
Have you mentioned that in your
Yes,
affidavit?
yes, we have mentioned in our affidavit.
Then
Otherwise, there is no objection to give it to her. That's why we have renewed the license in her husband's name. So she
You
failed
should
to
be
get an
lucky.
object.
You should be lucky.
There is another.
They are more kind. I thought they were not. Which municipality is this?
Bongaigaon.
Oh, very kind. The most kind municipality you have found. Yeah, what is it? You don't have a, the landlord tenant dispute.
In fact, I have filed a suit because there is an FIR which I've enclosed with the writ petition. When my husband died, they tried to enter into the shop premises, demolish the property, and I filed a compensation suit against the landlord and the other persons involved with it. they have not filed any eviction suit. What they have done, they have sided with the municipality and tried to stop the issuance of the trade license. For
No,
which,
we
for that
are-
my shop premises is closed.
But we have given the license to
no,
the husband.
Mr. Biswas, let us take a circumstance where there is a landlord-tenant dispute,
Yes.
where he cannot get that thing. Are you trying to act as a, if you don't grant the trade license, are you not therefore, because without the trade license, he can't work?
We have not made any objection. He working, she's running the shop.
No. Legally speaking,
Legally, that's true.
he cannot. So therefore, are you trying to evict the petition?
No.
By this process?
No. It is not my land. How can I be?
Normally the GMC does sometimes like that.
We have given the license. That's in the husband's name. Keep on. Carry on business.
How will they?
Well, since we are not objecting being a municipal board, that license, one license she has given fees. We have renewed it. She has given the fees. We have renewed it in the.
So then why don't you make it in the name of so-and-so presently run by the wife?
In that event, my lord, NOCs will require.
No.
Tenancy agreement.
Keep the name in the name of the husband only. But say through so-and-so.
My lord, with all
And
the-
names of
if
somebody
anything,
should
if
be
the demolished portion is collapsed and if any customer died, municipality board will be caught. That's why we also suggested you give a bond of 1 crore rupees. The compensation will have to be given. Suppose it is under demolished, it has been fall down. Then in that event, municipal board will be caught. That because you have not taken the measure to remove the dilapidated condition, there is the exhibit in your report. And meanwhile, 90% building has already been demolished. For all these problems, my lord, we have given this in her, let it be continue in the name of the husband.
Why don't you make the landlord a party?
There is a title suit in fact pending and it is.
Title suit is going on between
Who has
the
filed?
landlord and the.
I have filed it. For
Regarding?
Regarding compensation. Because there is an FIR that they have entered into my shop room and broken the articles of lordship in order to evict me. So against that, I have filed compensation suit and they have not filed any counterclaim or.
Okay, we have this on a better day. We'll have it on 16th of February. 17th, we'll dispose it up on that. 17th of February. You are not filing a reply.
No.
Then I may be given the liberty to file a reply. I'll enclose the renewed license at least.
Okay.
That is okay, we have
Mr.
submitted
Mukherjee, the learned counsel appearing on behalf of the petitioner submits that the Bonganga Municipal Corporation has filed a board, has filed an additional affidavit on 30/10/2025, and the petitioner would like to file a rejoinder. He further submits that recently also the Bonganga Municipal Board have renewed the license of the husband of the petitioner. Which he would like to bring on record. List this matter on 18th of February 2026.
Developed.
In the meantime, reply be filed on or before 9th February.
Prayer to withdraw the petition.
Withdraw? Name?
PR Sarma.
Mr. So-and-so appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. Taking into account the above, the instant writ petition accordingly stands closed on withdrawal. Ms. So-and-so appears on behalf of?
Mr. SCKL. On behalf of Mr. SCKL, Lordship.
Who?
SCKL.
Where's your Wakalatnama for him?
It's not responded, Lordship.
S.C. Koel? Who is S.C. Koel? His name is not here in the respondents. One is there, Union of India, Deputy Commissioner is there,
Lordship,
Assistant Commissioner is there,
for the department, Lordship.
Public Relation Officer is there. Then,
He is appearing for the department.
okay, none appears on behalf of the respondents. Yes, what is this case?
My lord, we have received some instruction, my lord, on verbally some discussion is also going, my lord. Lordship may fix the matter immediately after our reopening, my lord. He is already protected. We'll file our affidavit, my lord.
6 months?
No, my lord, because we have some urgency.
You have some urgency, interim order was passed in the
Yes,
year
that is why, my lord,
2024, you
immediately
have
after
not filed
reopening.
reply.
I'm praying for immediately after reopening, my lord.
Mr. Estoto appearing on behalf of the PNRD department seeks for a short accommodation to file the affidavit in opposition to establish this matter on 13th of February 2026, affidavit in opposition be filed on or before 30th 1 2026. Petitioner given liberty to file reply on or before 11th of February 2026. Interim order passed earlier shall continue till the next date.
Highly obliged, highly obliged.
Lordship, if I may pray for an accommodation today, Your Lordship, we'll file our affidavit in 2 weeks.
Second time, my lord, also contemplation where they are going submitted to pay the amount of contractual bill amount, but still that nothing has been done. So it is because
Lordship, it has come up for the first time since we have been engaged, Lordship. One opportunity may be given.
Consider as per that and pay it up as per Tamsir Ali.
Because Lordship, it's second round of litigation, that's why perhaps some instruction would be required.
Oh,
If
second round.
Lordship. Lordship.
Okay. Okay, you say last time it was submitted that as per the instruction, you see the process of making payment is going on and he wanted to obtain instruction.
Lordship.
Then
That's why, Lordship, one opportunity may be given for us to obtain that. Immediately after break, Lordship.
are you denying to the amount? No.
No, Lordship.
So you have to put it in the consolidated list.
Lordship.
Produce the consolidated list where the petitioner's name is.
Lordship.
Where?
page 21,
Page?
page 21,
Ah,
bill number 76, mostly one.
okay. Now what is your allegation? Madam?
After that, my lord, they were, after that, they have filed an affidavit where they have stated that the name was reflected in the consolidated list as 639.
Huh?
Six, after, they have filed an affidavit where they have stated that petitioner, name was appeared in the consolidated chronological list. Finding is serial number at 633 matter, that is paragraph 7. And feel that nothing has been done there. And only they have paid him only, he can choose manner. They have paid the money, he can choose manner. So, kind of identification has to go to the office. Sometimes they have paid up to 630, serial number 630, that is it. And while the petition, they have admitted that the petitioner name is appeared in the serial number.
And the petitioner was in 76. How did the petitioner become now 633?
That's why, Lordship, let me obtain instruction to that effect.
Friday?
One opportunity, Lordship.
Cost of 10,000 upon the lawyer.
Lordship will consider that this is the first time I've appeared.
Ms.
since-
A. Buzarbura, the learned counsel appearing on behalf of the petitioner submits that this is the second round of litigation. Pursuant to directions passed by this court, the petitioner was initially put under the serial list. It was at serial number 76 of the consolidated list. It is seen the learned senior counsel for the petitioner further submits that in the meantime, an affidavit has been filed by respondent number 7, whereby the petitioner has now been relegated to serial number 633. And there is no reason for doing so. The learned counsel submitted that this is a case of gross arbitrariness whereby the responding authorities are bent upon depriving the petitioner of his use. Mr. N. R. Sharma appearing on behalf of the petitioner seeks for a final opportunity. It is seen that on various occasions this court had granted time for obtaining instructions, but no instructions have been provided. Considering the above, list this matter on 7/1/2026. Instructions be provided as to what is the present status of the petitioner's amount and how the petitioner have been relegated to position to serial number 633, when the petitioner was at 76 earlier. It is observed that if the instructions are not produced, this court shall consider passing appropriate directions on the next date for seeking the personal appearance of the concerned authority. Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner submits that the petition has become infructuous, taking into account the above the petition stands closed. You are appearing?
Yes, Forest.
So and so appears for forest.
Good.
কি মেটা বলে দাও? Raju Chauhan, OA2.
The lordship was filed a IA for your lordship vacation.
What is this matter?
That IOCL allotting, selecting the respond number 6 for retail outlet dealership, wherein the petitioner was also one of the participants. The pieces was dropped. Appendix 7A, that is the OBC cum NCL certificate. Now, there was an order, my lord, the very first order.
I see, production list.
What is this? Who has given this? Regarding?
Regarding that authentication of the document lordship, that page 141, elected. Last order of the.
Okay. You do one thing, you file it by way of an affidavit.
No.
This is necessary because we can't dispose it of it. Mr.
Lordship, I beg
S.R.
pardon.
Purva, pursuant to directions passed by this court dated dated 8/9/2025 has produced a set of instructions. It is the opinion of this court that these instructions be placed by way of an affidavit so that both the petitioner and the respondents can take, revert can revert to the same. Accordingly, list this matter on 6th of February 2020, and we'll have it before 30/31/2026.
Your Lordship, can it be immediately after vacation?
Here's the file. The problem is them, na?
Your
Who are you?
Lordship, I beg pardon of Your Lordship, that annexure, that clarification has been sought, Your Lordship. That was not even relied while granting the Your Lordship dealership
Who are you?
appointment letter, Your Lordship. That affidavit, Your Lordship.
Who are you?
Your Lordship, I'm for the respondent number 6, Your Lordship.
So, how do you know it was relied or not?
Your Lordship, the affidavit filed by the Your Lordship.
Are you going, are you
Yes, sir.
hand in glove with the IOCL?
No, Your Lordship, I have.
Were
received the
you
copy of
present
the
at the time when it was considered? Let them file, no heavens will fall. This is for what? Retail outlet?
Retail out.
Ah, don't worry. We'll look into it. We'll have it on 29th.
29 January.
29 January. On 29 January, the affidavit be filed by 27.
Your Lordship, 29, perhaps my senior Mr. Ken Chaudhary will appear. He will not be there perhaps. Can it be on, immediately after Your Lordship, the 20th
We'll
or
have it on 18th of May. On 18th of May 2026. Interim order passed earlier shall continue till then.
Your Lordship.
18th May?
I beg pardon, Your Lordship, Your Lordship. January, any date, Your Lordship.
No, Mr. Counsel, first and foremost, you have to understand. There. Number two. Number two. Seeking adjournment in respect of any matter listed, we have seen not permitted.
He will not be there, that is why, Your Lordship.
So I'm not concerned. Senior counsels, in my opinion, are daily wages.
I beg pardon, Your Lordship, any day in the month of
Tomorrow
January,
they
Your Lordship.
may be engaged, day after they may not be. So,
Up to Your Lordship.
has the client approached Mr. Chaudhary or the client approached you?
The client approached me, Your Lordship.
So, you can take me any other senior counsel. You want the list of the senior counsels? We can provide you. It is also available in the website. Get hold of, or get many counsels from Delhi also. It's a retail outlet. Get it from there. So, yeah, 29th. You file your affidavit by 27. Sure.
In the IA, they have filed for vacating of the stay.
Good stuff. When did they file?
They filed it today, I suppose. But they brought it by way of production list.
Oh, today?
I think.
Yesterday, Your Lordship.
Oh, yes.
Okay. This court have duly heard the learned counsels appearing on behalf of the parties. And pursuant thereto, it is the opinion of this court that the impugned order, that the interim order so passed by this court, dated 8/9/2025, is required to be continued in view of the instructions so produced by Mr. S.R. Borwar, the learned counsel appearing on behalf of the district administration. Accordingly, the interim order passed on 8/9/2025 is being extended till the next date, that is on 29/1/2025, in presence of all the councils. I can लिखी. Right. No, ऐसे आए था वो. You want time?
My lord, you want
6 months time?
Tamsher Ali's direction may be.
4 months?
I may insist, my lord, Tamsher Ali's.
No. You are PhD. PhD Tamsir Ali doesn't apply.
Then
4 months. No, for filing affidavit.
oh.
You cannot allow Mr. Bora to have a walkover so early. When he's on the other side, he really takes the toll, asking for time. The BTC is still suffering till now. Huh? And Mr. N.R. Sharma is having the fallout. How much? 6 months. Big time.
3 weeks maybe.
Which is this matter?
Not non-payment of contractual due.
PHE, na?
PH.
PHE. It was four directions. We dispose it of. 6 months you have to pay. But first, these 4 rounds, he submits the work orders and all these things. You have seen, na? That is the 4 directions.
Verification.
Verification. First, he has to say, you look into not only the verification work done, whether he has submitted all documents, everything. Then only.
Okay.
You have filed affidavit.
Yes, they have filed. Yesterday.
You want to file reply?
Reply 2 weeks time.
The counsel appearing on behalf of the petitioner seeks some time to file reply. List this matter on 28 1/2026. In the meantime, the reply be filed on or before 22nd. What is this order? No interim order given. Who is the private respondent? You are the?
I am appearing for APTT, Provident Fund.
Okay. Anyways, I think you file your reply. Look at that. Eh?
There is an interim order not to finalize the contract.
Your file reply?
No, we file.
When?
No, it's not a 2 weeks time. Immediately after vacation. NHDC has filed apply affidavit. And the matter is, I think it is of importance to them also because supply of 32 commercial vehicles. They said, my lord, that we were disqualified. Then thereafter, my lord, we were qualified. The reason is there, my lord, that they have given the reason we are L1 bidders. Paragraph 8 of the affidavit filed by the respondent, my lord, respondent authorities. There is a provision for if there is a shortcoming, my lord, within 96 hours, if it doesn't change the character of the tender, my lord, we can upload. So one certificate was lacking, so we have uploaded that. The lordship may kindly see paragraph 4, our affidavit, filed by the respondent number 4.
Anyway, Mr. I will have it after vacation. There's an interim order, so we'll have it on 6th. 6th we are having it. We file your reply because it has been a long time they have filed the affidavit.
One issue, James appearances result. Jail portals appearances result. Because they have come up with an issue. But there is certain sort of clarification should come from the team. Otherwise, it will be difficult.
Jem need not appear because if you see the GEM's terms and conditions, it is mentioned that the procuring authority will appear on behalf of the GEM. If you look into that, these are the terms and conditions. So, you see, when you employ GEM, you are either employing the GEM, na? GEM doesn't want to come over unless anything is there. They are saying that we are going to do this, we are just going to float it. It is you who is going to decide. We are not going to do anything.
They are saying none of that.
So it is the procuring authority who has to represent GEM. This is how it is.
22nd, my
none of
lord,
that. Even
22nd, they have shown the shortcomings of many candidates. And out of that, two responded we have to respond within a period of 36 hours, 96 hours. So we responded on 24th, saying the one certificate was not there, we uploaded that, then our certificate, it was accepted. But that provision is there, otherwise, my lord, it will not be accepted.
Now, and
by the
remember,
courts.
your case is that L1 and L2, who have been later on looked into, they were technically disqualified, but their financial bid was over.
Yes.
That is your case.
Yes.
And his case is L1, maybe initially it was rejected, but I was given an opportunity and I therefore corrected.
That's all.
So the
Otherwise,
question is whether it is permissible or not.
Yes.
But the fact remains that the affidavits were filed on 21/11 and 1/12. You have not filed your reply.
It shows their negligence only, my lord.
Absolutely not, my lord. I strongly say, but my difficulty is that my petitioner was not in Assam. He went to somewhere else for an event, my lord, because he is in field service, my lord. That's why. That is the issue. Now he has come up, my lord, and I've gone through, my lord, there are certain important issues to be advanced in respect of their issue, my lord.
Okay.
Sir,
Mr. SP Bhattacharjee
sir,
appearing on
Schedule 7, my lord.
6-1.
Mr. SP Bhattacharjee, the learned counsel appearing on behalf of the petitioner. A week's time for filing the reply to the affidavits filed by the respondent numbers 1 and 2 and respondent number 4. So taking into account the above, this matter on 7/1/2026. So the reply be filed on or before 5/1/2026 by providing advance copy to the councils appearing on behalf of the respondents on or before 31/12/2025. Full stop. Interim order pastorally shall continue in the next.
Will come on 7 January.
Why no tender process?
I have received the instruction.
First of all, have you stopped him running or not?
Lordship,
Why is he running till 8/12 without having a night?
As on today, I'm not running. Somebody else running.
Yes, what about my second sort of instruction which I have sought for? How was it running till 8/12?
Lordship,
How was it running till 8/12?
Lordship, I don't have instruction to that effect, Your Lordship.
What?
I don't have instruction to that effect, Your Lordship. That whether, how he was allowed to run till late.
Let us see the face of that person who is the director of fairs and markets, no?
Or Lordship,
No, no, no.
Lordship, let us file an
You-
affidavit to
It
that effect.
seems that you are taking it very lightly.
No, Lordship, I'm
No,
not-
no, no.
no, Lordship.
This court had passed an order on 10/12/2025 inquiring as to how the petitioner had been permitted to run the Borimoka cattle market up to 8/12/2025 when there was no settlement made in favor of the petitioner during that period. No instructions have been provided on behalf of the BTC. On the other hand, Mr. K. Gogoi, appearing on behalf of the state government, submitted that the cattle market, na, is a transfer to subject. The settlement of market is a transfer subject after the Department of Market and Fairs, BTC, looked after by the Department of Market and Fairs, BTC. Full stop. This court have also seen that there is no, that the said authority, that is the respondent number 3, have not provided any instructions. So considering the above, list this matter again on 7/1/2026. Full stop. It is observed that if the instructions are not filed by way of an affidavit on or before 5/1/2026, the secretary the respondent number 3 shall be present before this court at 10:30 a.m. through the video conferencing link to be provided by Mr. N.R. Sharma, the learned standing counsel of the BTC. In the said affidavit, the said respondent shall categorically deal with the query as raised at paragraph number 6 of the order dated 10/12/2025.
Vice Lordship.
Not yet refunded money, neither money regarding their license.
They say there is no provision.
Provision, my lords. I spoke with the secretary a few minutes ago as commissioner also. They are willing to issue his license processing. It's under process. It's under process. His license is under process. His license is under process, will be given to him very shortly if he wants it. But other provision, other issue, I'll admit, since there is no provision, the issue, if the courts direct also, if court directs that refund him, but there will be a timeline. What has happened, my lord, this because of the additional budget has to be procured and he has to refund it from that. It will take some time. Time frame of almost 6 months will be required.
Okay, with interest. Banking rate. Banking rate interest 7%.
That interest part may not be imposed on us.
Why?
Otherwise, my lords, since if the rule would have provided, my lords, we would have given him if this one is some rule.
If you don't have a rule, then under such circumstances, he is additionally more entitled to. Do you have a rule by which you can appropriate it?
No.
If you don't have the rule, isn't it therefore the provision is you cannot appropriate anything without having the authority of law? Where is the authority of law to appropriate?
Normally in license issue, case of license.
You don't
we-
require a rule for refunding, but you have a rule for appropriating. My question is that.
My lord, we, as regards license fee, my lord,
If you are not in a position to issue the license,
for feature, my lord, regarding my lords, the security deposit, there is a rule of forfeiture. I've been told. so.
rule of
Forfeiture for the security deposit, forfeiture, my lords, we can forfeit. The
It's
initial
not a security
No,
deposit.
initial bid.
Well, where is that provision?
That initial.
You have not issued the
My
license.
lord, license is under active consideration. lords. I just spoke with, I applied him also. Just give me some time.
I did, I take instruction from my client, but now another, today's stand is different. They say that we are in possession, license is in process. The earlier, my lord, they says that they are not going to issue because the permission was done. So, my lord,
In fact, by
because of
next day, well, I can also be very clear from the authorities that how much exactly, if they are issuing license, how much time they'll require to actual come in black and white. In the meantime, my senior also can take instruction if the petitioner is now willing to take or not.
Why will he say? First you come up and say that we are going to give you.
Yes, exactly.
He is fed up
Yes.
with you. Because of you, he's there fed up and said that, okay, I don't need a license, give me my money back. You are trying to appropriate on the ground of refund. I think we should.
No,
this
my
is
lords.
a-
No,
This is
there's
a
no
case
intention.
for writing a good judgment.
My lord, there's no such intention, my lords. I'll be
It
very
is
clear.
like that.
There's no intention.
There is a question of it is absolutely, it's a case of appropriating.
No, my lords,
It's a
not,
case-
yeah, we don't have any intention of that, my lord. The
Huh?
only issue is red tape. That red tape is the, my lord, which says nobody is taking the call. So that's why I've been advised to seek some time to, if by what time I can issue them, we can issue him license.
Don't make that submission unless you have written instruction. Tomorrow you may say, then if Mr.
No,
Bothakul
these
will again
authorities-
appear, say that Mr. Gogoi was, or Mr. Gogoi will appear and say that, look here, Mr. Gogoi was nothing to say about this thing. He
No,
has
my lord, no, no.
incorrectly mentioned.
this-
I don't trust, Mr. Gogoi, I don't trust the PHE, the excise councils when they make this type of submission. I make it very clear. And this is a reason because of your conduct. So therefore, don't make this submission on verbally. All has to be written instructions from you.
Well, I'll get it written. I'll get it written because excise
Otherwise,
can
I
know, my
don't.
lord, because PH is a bit different.
PHE and excise, I put it out there in the green book, not yet blacklisted. Not blacklisted for the other two councils. They are not so like that, can be trusted. Anyways. Okay, Mr. That submission also cannot be taken into account.
My lords.
Taking into account the paucity of time, this court today adjourns this matter again on 21/2026, which will be taken up and would be taken up at 2 p.m. for final disposal. First, this court have also taken into account the stand of the excise department, wherein they say that the petitioner is not, that there is no provision for refund of the initial bid money. This court inquired with the learned counsel appearing on behalf of the excise department as to whether there is any provision in law by which they can appropriate to themselves the said initial bid money without issuance of the license. Mr. D. Gogoi submits that he would obtain instructions. List accordingly.
Objection, members.
Yes.
It's the tanker matter. This is the tanker matter where the validity of the SEOS scheme was under consideration.
Anyways, I think Bank of India is doing something. Whatever happened? What is your stand? You have given up, na? Are you still going to give them the guarantee? Then what are you doing in view of theirs then now?
We have to cancel the bid of the respondent number 8.
So nothing remains in your case then?
That is recorded in that can be the end of the matter.
Liberty may be granted to take appropriate action on the.
Very well.
We have it after vacation or does it not? Oh, no, I'll record this.
Yes, yes.
And then you may say it has become infructuous on the next day. Better, na? Let us reserve something for the next year also. Mr. A. Ganguly, appearing on behalf of the Bank of India, submitted that taking into account the decision of the central government, more particularly the respondent number 5, whereby the SIUS, na?
It's SUIS.
SUIS scheme have been withdrawn. The respondent number 6 and 7 have duly intimated the respondent number 8. 8, na?
No, my lord, they have not intimated. They have filed an affidavit.
No. Intimated. To the respondent number 8, na? Respondent number 8 as well as the IOCL, that they have withdrawn, that the Bank of India have withdrawn what was that document they have submitted?
Yes, the document is at page number 157, Your Lordship. It's a confirmation letter.
Have withdrawn the their offer to the respondent number 8. As regards financing his project. Mr. N. Burwa, who appears on behalf of the respondent number
1, 2, 4.
Huh?
1, 2, 3, and 4.
1, 2, 3, and 4 submits that that the IOCL authorities have also been intimated by the Bank of India.
No, we have not yet received.
Huh?
We have informed.
Okay. He would obtain instructions as to whether the Bank of India have intimated the IOCL authorities about withdrawing their finance to the project of the respondent number 8. And if that be so, the IOCL would reject the letter of acceptance so issued to the respondent number 8. Full stop. Taking into account, he therefore submits, Mr. N. Borwa therefore submits that some time is required in that regard. Full stop. Accordingly, list this matter on 9th of January. You can get it done. 9th of January 2026 for an update. If he gives that update, he is withdrawing, then in that case, the petitioner's case is done. Then I don't need to say anything.
Regarding.
I don't need to say anything in that petition. I could close the petition. Issue will remain open.
Your Lordship, there is one.
Don't. Because of you, this problem has arisen.
Yes, Your Lordship.
Don't come up with all those things.
Yes, Your Lordship.
If I'm not passing a direction out there in his relief,
Yes, Your Lordship.
if he withdraws or if he says that his relief has been selected and nothing remains, then why should I to say anything about yours?
Yes, Your.
You should be quiet and happy.
Yes, Your Lordship.
Yeah. Coming here, you have caused yourself a problem. Yes.
Should be listed in the admission column.
Yes.
So and so in the admission column.
My senior will be appearing later.
Okay, let us take it on 19th.
19th.
This is the matter on 19th. Are you serious with this, Mr. Kerr? You have not taken steps. For response number 1 and 2, it's a very old matter. You have nothing to do for. Oh, these people have no business out there. Acha paper project employees. Paper mill.
That has.
Huh?
The paper mill is not.
No case, no case. I think this matter have gone to liquidation. That is also finished. HPC.
Let me have some time to obtain instruction.
No,
Maybe close
I'm
your-
closing it. It seems the petitioner is not interested. So much time has been given to you for taking steps upon response number. And the most pertinent thing is, response number 1 is no longer in existence. Then
So my lord, maybe close with the liberty that if they. have
approach the
events-
appropriate forum.
Yes, fine.
Full stop. It has been submitted by Mr. A.K. Sikdar, the learned counsel appearing on behalf of the petitioner, that the respondent number 1 have already been wound up. And as such, the petition 1 and 2 no longer is in existence. And therefore, the petitioner has to avail remedies before the appropriate forum. Taking into account the above, the instant writ petition therefore stands closed. However, liberty is given to the petitioner to approach the appropriate forum. Do you connote? A?
Yes.
AR.
A.K. Sikdar is my father.
Okay, okay. AR. Chalo.
My lord,
Do you connote?
for item 33, need a maternity pass for the day at my senior. Like.
33 finished. 32, 33 finished. Closed. You are fighting against a dead person. Dead person you cannot fight. Do you want to go somewhere to hell or heaven and fight? Huh? These are dead people. It is not, it cannot be done anything else. I am doing a matter now where it's a big fight going on as regards the machineries. Who is going to demolish and break it? And there you want a right of retrenchment. You have to go before the official liquidator. Go. Yeah, no.
My lord, Hindustan Paper Corporation of Calcutta office, there is no.
Same here also. Hindustan Paper Corporation. Go on. Closed. It is not in existence.
The last opportunity.
No, Mr. Biswas, it is not in existence. That is what I was saying those. Nothing is there. It has gone into liquidation. Therefore, I said approach the appropriate forum. I think you may go to NCLT. There you may get some idea.
Similar order passed in the other case, similar order.
Yes, same. Not in existence, so it is good. What is this? 35. Okay. None appears on behalf of the petitioner on call. Good stuff. The present contempt application has been filed, alleging willful and deliberate violation of the order dated 22/3/2018 passed in 2064/2016. It is seen that the petitioner have not taken any steps pursuant to notice having been issued. And thereupon, the matter has been listed after 2019 on 27/1/2025, when the petitioner is not represented. It therefore appears that the petitioner have lost interest in the instant proceedings. Be that as it may, it is also relevant to take note of that an inquiry being made up to Mr. G. Bokial, the learned counsel who represents who is the junior government advocate.
Yes, ma'am.
Who submits that the officers who have been arraigned is no longer holding the said officers. So consequently, the above, the instant contempt proceedings cannot be proceeded in this manner for which the contempt proceeding stands dropped.
6.
It is a lordship. The covered case, your lordship has already passed an order and there is a division bench order also, same point. When a matter pertains to double forest royalty, the payment of double forest royalty, the lordship produces the last order, my lord, of this honorable court.
মই তো ঘুমাই আছিলো NC Das.
Order dated 6/8/2005.
এখন কেলে
Then,
Now, my lord, pursuant to this order, my lord, we have filed one additional affidavit, but showing that the concrete mixtures which we have supplied for Numaligarh refinery, we have taken from a third party.
why the matter has come up?
My
Some
lord,
additional
it has come up
affidavit
for-
has been filed.
Yes.
Okay, so we'll have it on for admission.
My lord. My lord.
You want to file reply?
My lord, we don't have such a role, my lord, because
You are the main.
no, my lord, we didn't deduct anything. It is the contract between NRL and the
Mr. D. Gogoi, you say that we don't want the forest royalty? They won't. Isn't it? Give it, tell.
then, my lord, we have to perhaps authenticity of this.
You are the main problem here, for which all are fighting. You do one thing. Look into this, we'll have it for admission. He says it is covered by one judgment.
Yes,
I remember that judgment of, I think, this person concerned, na?
NC
No,
Das.
no, that's Muslim Ali.
No, my lord. There's another one also, my lord. NC Das.
Oh, yes. Which one?
NC Das is of 2022.
In fact, my lord, after filing of this additional.
In fact, lordship has passed the judgment relying on NCDAS.
Yes.
The source has to be, source of procuring has to be legal and that can be looked into.
That is why this additional affidavit was filed.
Okay.
Well, I'll verify with the.
Have a look at it. Taking into account the office note, list this matter on 30/1/2026 for admission. In the meantime, Mr. D. Gogoi, the learned standing counsel of the Forest Department shall obtain instruction in respect to the additional affidavit filed by the petitioner.
Fine. Obliged.
Mr. Dekka, you give your name, huh?
My lord, twofold directions was given for earnest money and my lord, last occasion.
No money before vacation.
My lord, his bank drafts, so and so, so and so. Bank drafts were sent to his office, which are returned because the address was insufficient, my lords.
Huh?
We'll collect it, my lord. It is now in our office, my lords. We had issued, those were sent to him by post. It was returned because address was insufficient.
When it was sent?
Yes, sent
Bank
to
draft
register.
dated?
My lord, dates are not mentioned, my lord, but
16, 12,
No, bank
2025.
drafts will have date, na?
no, my lord, this is just this is,
Nothing, my
there's a lying there, my lords, in the office. Now is in my office, my lords.
No, when is it alive or not? If it is alive, let them go and collect it.
But he has some.
This way, my lord, we'll collect it from their office. There is no problem. We'll go there, collect the FD from the office. Only direction may be given to hand over the thing.
That is our instruction, man. It is lying in our office. Earlier it was
Is
sent.
it
but
valid or not?
That, my
Bank
lord,
draft is for 3 months. My question is that, when was this instruction?
Well, there is a FD, my lord, interest, there is a FD, my lord. FD we have given there.
These are not bank drafts.
Oh, my lord. FD.
FD.
Bank draft.
No,
In-
FD, my lord. Yeah.
our instruction is written bank draft, but my lord, after let my lord petitioner collect, then my lord, we will see if there's any issue in.
Let us have it on 19th. You bring those bank drafts and give it to him.
Yes,
Matter what?
that is the best way.
No, it's not, my lord, it was his own address. It was returned, my lord.
Nothing has been given, my lord. Why I will not accept, my lord?
Insufficient address,
It
my
has
lord.
not been sent. It is saying
No,
that
it is
like-
insufficient address means it is lying with you.
Yes, it is lying.
So go and bring it and give it to him in
But
this
the
court.
next
The
two
court
guys-
will recognize and close this court. Because otherwise what happened? I asked him to go. He goes. Then you say, you give him. Then later on happens. So it's a simple thing. You give it. You
Simple.
make it easier.
Lordship,
Or
this is
if
very
you,
dumb.
because if I say, give it to him, but then also I can't close it. Till you don't give it to him.
19, my lord, let them bring, my lord.
It's a simple thing. You get the bank draft. Where is it?
It is not handed over to us, my lord.
No,
It is,
where is it?
in the office of the additional chief engineer, Upper Assam Zone, Nagaon.
Okay, then it is okay. We do one thing. List these matters again on. Now, it has been submitted by Mr. D. Gogoi appearing on behalf of the respondent that the bank drafts in question were sent to the petitioner addresses but returned on account of insufficient address. Full stop. Mr. S. Samaria, who represents the petitioner in the present batch of contempt application, submits that these are not bank drafts, but rather fixed deposits. And the petitioners are not adverse to appearing before the office of the additional chief engineer, PHE Upper Assam Division. Na?
Zone, Upper Assam Zone.
Zone,
Upper Assam Zone.
zone, Nagaon.
Nagaon, for the purpose of receiving the bank drafts in question. Full stop. List this matter on 21st of January 2026. In the meantime, the petitioners are given liberty to visit the office of the additional chief engineer so-and-so. And upon, if the petitioner's duly visits, the concerned respondent shall hand over the fixed deposit and obtain due acknowledgements, which shall be produced before this court on the next day.
Right.
It will solve the problem. Equal. Yes, sir.
This matter was, it's for an update as to whether we have not received any amount.
My lord, I have received the instructions yesterday. The financial sanction has already been given and they have moved the finance department for concurrence on 16, my lord.
Lordship, sealing proposal has been sent yesterday, Lordship. I've talked with the department. There, 2 working days, concurrence will be given. After that.
You come up with such a manner that I can't take it off then before petition.
Lordship may
Huh?
fix it on
These
first week.
2 working days, we have put it so that I relegate it. No, is the vacation bench sitting? Then we can take up this issue.
Lordship, by vacation bench, the payment should be made, Lordship.
Huh?
Healing proposal was received yesterday, Lordship.
What is the total amount?
Total is 1 crore 38 lakhs, my lord.
1.20.
1.20 now we are paying because of the.
There's a balance left after.
Some balance is left, my lord. In the next budget, we have to pay that.
Only a part of the bill.
Why you are not paying?
Well, already the departmental finance committee has accorded approval, and we have already moved the finance department. The concurrence will come within 2-3 days, and accordingly it will be released, my lord. It will take after concurrence, my lord, it will take another 4 days, my lord. 3-4
Yes,
days.
4 to 5 days, this amount will be paid, Lordship.
Then
Okay, if you delay next time,
By this year, my lord, they will.
take it as a guarantee from me that unnecessary matters I will be asking both of you to appear from next time onward, every time. And parents, when this court asks, it is free of cost, then you will understand the pain and agony of your opposing counsels.
Oh.
Unnecessarily, you are delaying the matter.
No, my lord, we are trying, my lord. We are trying, my lord, and they.
Lordship, this amount will be paid within this year, Lordship.
Yes.
Yes, this up.
From 2 days now, it has gone to this year.
Lordship, financial concurrence will be given within 2 days, Lordship.
After concurrence,
okay.
3-4 days, my lord, will take.
It has been submitted by Mr. A. Solia, who appears on behalf of the Finance Department of the Government of Assam, that the Finance Department have already received the proposal and the same would be cleared within 10 days,
4 working days, Lordship.
within 4 working days. Full stop. Mr. N. Nath, D. Nath, the learned senior government advocate submits that the said amount thereupon would be credited to the bank account of the petitioner. Full stop. List this matter on 7/1/2026 for an update. Full stop. On the next date, so both the councils appearing on behalf of the Home and Political Department as well as the Finance, Home and Political as well as the Finance Department submits, shall also apprise this court as regards the remaining amount.
Manoj, as regards, it number? 45. So as regards 43, item number 43, instructions are awaited. And regarding the 44, we have received instructions where a part has been admitted and part denied.
Some payment received.
No, madam. So 43, my lord, if I may submit, madam, that your lordship can direct.
We are on 43.
43.
44 file is there.
Yeah.
So 43, my lord, can perhaps dispose of with a direction to verify.
There are 4 directions. You look into all the papers, completion done or not. Either you have submitted the vouchers and all, then verify as to whether done or not. After verification, if it is found that he is entitled to make the payment, but all these things within 6 months from the date certified copy. Chalo, disposed 43. 44.
I understand my friend has received instructions regarding admittance of part of the amount.
Huh?
One of the amount claimed is 11 lakhs 92,000, my lord. I understand that my friend has received instructions regarding admittance of part of the amount.
You have received.
But my lord,
Yes,
my friend has received instructions, I have not received.
Then we do one thing, same order, down below it will be said, any amount you paid shall be set off. It's set off to logai dibo. Ei duita te logai dibo.
Obligation.
My lord, 3 months time has taken by that department for filling that law.
Yeah. Some of the requisite documents have not been submitted by the executive engineer, my lord. So chief engineer has asked him to submit those documents, administrative approval and those documents, my lord.
You have admitted the amount of 1385.
Yes, that is.
Then why have you not paid?
But
Problem is there, na?
Yes.
You see, the problem is this. If you don't make the payment, this court has the big, you see, main problem is, once you issue notice, I can't later, on, just for example, just few matters before, item number 35, could see I could not pay a contempt petition to be dismissed for default. This I can do because I have not issued notice. You see, this is a way, yeah, once you issue, if you make the payment, you say that would be clear within 3 months and I have fixed now. Now why you are taking that issue? This is the order, 26/9/2025. Then, Mr. Vattakur.
Suddenly, my lord, Office of the Chief Engineer has, my lord, given this communication, my lord.
So then I'll issue notice because then it amounts to. No, this is a notice to contempt. Why initiation of contempt should not be initiated? Actually. This matter again on Mr. Ibo Thakur, the learned counsel, this matter has been listed almost after 2.5 months from the date from 26/9/2025 for an update. First, list this matter on 19/12/2025 for motion. There I will issue notice of contempt.